What is for the insurance company? Sierra, what is the matter? What is it say? No. Wait. What is his information? Yesterday, the advocate here. What is his information? Yes. Neotia has been removed. Okay. And after doing the scanning, for the was not possibly supplied. It was done in the garden city. And after the city can go that. Okay. So taking that to the can start. Yes. Number one, your client is present. आपने ये फाइल किया पिटिशन आपने फाइल किया ये सेटल हो गया आपके बीच में
सेटलमेंट हो गया आपके बीच में
सेटल हो गया
यस यस शी इज सेइंग यस
क्या नाम है
शांति पाकरी
शांति
पाकरी
शांति
आधार कार्ड इज देयर
ओके Yes, is Mr. Chakraborty?
Member, military organization. As per the citations, member.
The matter is pretty dispute.
This revisional application is filed by the petitioner under section 482 of the Criminal Procedure Code. For quashing of proceedings being special GR case number 56 of 2021 pending before learned additional district and sessions judge first court at Darjeeling arising out of Bagdogra PS case number. What is the PS case number? 393? 393? 393 of 2018, dated 28 December 2018, under section 447, 427, 448, 506 of the Indian Penal Code, read with section 31A, 31G and 3110 within bracket X of Scheduled Caste and Scheduled Tribe Act.
The brief fact of the case is that the opposite party number 2 complainant lodged FIR with the allegation that she rented let out. She let out a shop room to petition number 1. And on the ground of non-payment of rent, she filed a suit for eviction. On the date of occurrence, there were oral buy-in between the parties, and the opposite the petitioners group used abusive languages on the de facto complaint. So on such allegation, Bagdogra Police Station case number 393 of 2018 was initiated against the petitioners. For quashing of such proceedings, the petitioners have preferred the present revisional application.
No, that's also fine. That's also fine.
Huh?
That's also fine.
Ms. Siddhi Sethia,
Yes, ma'am.
learned advocate for the petitioner, submits that the matter has been amicably settled out of court final between the parties. Relying on the decision of Honorable Supreme Court in Rama Avatar versus State of Madhya Pradesh, reported in AIR 2021 SC 5228, he submits that although the prosecution has been initiated under the SC/ST Act, but since the dispute is civil in nature, the matter can be settled between the parties. Mr. Niloy Chakraborty, learned advocate for opposite party number 1, also submits that since settlement has arrived by and between the parties, the matter can be compromised. Ms. Shreya Basu, learned advocate for opposite party number 2, de facto complainant, is present with the complainant. She admits that the matter has been settled amicably between the parties. In compliance to order dated 3rd August 2023, the de facto complainant, Mrs. Anki Pakrin, has appeared before the court. On query, she states before the court that the matter has been amicably settled between her and the petitioners. Copy of the judgment. Upon perusal of the complaint, it is found that the dispute between the parties is civil in nature. The Honorable Supreme Court in Rama Avatar versus State of Madhya Pradesh, para 16 of April. Sit out, para 16. Bearing in mind the aforesaid, since the matter has been compromised by and between the parties, there is no impediment to quash the proceedings. Accordingly, the proceeding being not approved stands for the revisional application being CRR 142 of 2022. Along with TRAN 2 of 2023. 2 is your joint application.
Yes, ma'am.
TRAN 2.
This pen is a joint.
TRAN 2
It's pen.
allowed. No, this is working.
Whether it is required, the matter is pending in additional
Special GR case number that will
For the state, madam.
On the last occasion, may I find out?
Yes. CD has come. CD.
CD was called.
Yes.
My lord, then just pass over the matter like this. I mean. जल्दी करें
Item 3.
Yes. Yes. The other side is present. Other side is present. Mr. Majumdar is. Yes. 39. Yes, Mr. Basu.
Mr. Basu, you are not audible.
Hey. দেখুন ওটা কি হয়েছে
Well, this is my application. I'm sorry. Item number 15.
I am in 3.
Oh, I'm sorry, Mr. Basu, your lordship.
Yes, Mr. Basu. দেখুন তো কি হয়েছে You are not audible.
My lord, I am in item number 15. Your lordship has called item number 3 possibly.
Yes, I called item number 3.
Both are Basu's, my lord.
Oh, one is HON'BLE Basu and
Oh,
Mr.
no. Sorry. Mr. Basu.
Mr. Basu, I am talking to Mr. Apollo Basu.
Oh, I'm sorry. I'm Kollul Basu.
Yes.
My lord, am I audible now?
Yes.
I'm very sorry, my lord, for the glitch. My lord, this is against an application where, my lord, the learned special judge CBI court had turned down my prayer for recall of 2 witnesses, more particularly witness number 71 and 73, my lord. 2 witnesses. May I just tell your lordship the facts of the case. 71 and 73 are the sanctioning authority and, my lord, the investigating officer of the case. Now, my lord, this case pertains to the disproportionate asset of a government employee, where the check period, my lord, would be surprised to find is about 25 years, my lord. It is alleged that he had, my lord, acquired certain assets beyond his capacity. Now, my lord, in cases of this nature, my lord has vast experience, my lord, that what has to be seen here is, my lord, everything, whatever he had acquired officially from his office service, my lord, everything has to be accounted for. Now, my lord, prosecution had examined 73 witnesses from the year 2000, my lord, it started. But 2003 was the time charge sheet was filed before the learned special court. Cognizance was taken on the basis thereof, my lord. And, my lord, thereafter, my lord, there's no denying the fact the defense was also, my lord, given an opportunity to adduce their own witnesses. However, my lord, in spite of, my lord, adducing defense witnesses, it was realized that 2 things were clearly lacking, my lord. One, essentially, was, my lord, certain rewards. My lord, the entire service book was not exhibited before the learned special court. There was certain, my lord, to say this in this way, my lord, there was certain withholding of documents, which, my lord, have 2, my lord, effect, twin effect, my lord. One is, my lord, the best evidence for the court to come to a conclusion, and which was not also available with me, because, my lord, I cannot have all details of my service. Since, my lord is aware, my lord, it cannot be there with the employee concerned. He's a 73-year-old man, my lord, and he had retired long back. The documents are not with him. One. And second, my lord, what are the documents which were also placed before the sanctioning authority, my lord, for his consideration to accord sanction, my lord. So, my lord, all we wanted was just to, my lord, cross-examine these two particular witnesses. It was not a, my lord, cryptic, my lord, straight jacket formula for examining maybe 8-10 witnesses. Not of that nature, my lord. Sorry, my lord.
Please hold on. The first
Sorry.
document is relating to service document.
Service document. My lord, my application under 311, if my lord so peruses, is at a, my lord, is annexed to my petition at page 41
So
of my
kindly
application.
clarify service
Sorry.
document of your client.
My lord.
And what is the second one?
My lord, may I just take your lordship to page 42? I have mentioned that service book, personal file, and documents showing reward or earned arrears, my lord.
Reward.
My lord.
Yes, continue.
And my lord, arrears of pay bills and registers. My lord, page 42, paragraph 5. I had mentioned everything. This was not a an application where I tried to, my lord, misguide the court or my lord tried to deter the prosecution. Page 42, page 5. My lord, paragraph 5, sorry, my lord. 4, 5, everything.
Yes.
So, my lord, that was a very small prayer. My lord, all I beseech your lordship consider is, my lord, now the law is, my lord, crystallized. The law as it stands now, my lord, is for any application under 311,
Yes.
the learned trial judges are given the power to order it till, my lord, the final judgment is delivered in the matter. The purpose behind this is, my lord, to afford the learned judge to have the best evidence possible before him and such that no party feels prejudiced. My lord, the stage, as it stands, I will place the judgments, my lord. The stage of a proceeding where a 311 application is made is probably secondary, and only when the court otherwise is satisfied that the evidence which it tries to place before the court cannot have any material bearing on the final outcome of the case, that the court will, subject to lordship's kind correction, reject the application. Because, my lord, 311 is an application which effectively is something which causes or advances the cause of justice, my lord.
But
My
that
lord,
is
here, sorry, my lord,
the judge holding trial.
for the charge holding trial, my lord. My
Now,
lord, here, sorry, my lord.
service documents are concerned, you have submitted that for calling for examination of defense witness, you were given the opportunity to adduce. Correct?
True, my lord. Correct, my lord.
At that time, what was the endeavor taken by the accused to
My
call
lord.
record if that was lacking in the trial record?
My lord, may I just express this? My lord, in a case of this nature, while I knew that I was protected under Article 20 of the Constitution, I took all efforts to examine myself, my lord. So anything and everything which is there on record, I have had the, my lord, the prosecution had the opportunity to cross-examine me as well. But the only difficulty is these documents are of such nature, my lord, which were not made available to me, and of, my lord, in national courts also they will not be made available to me. Because, my lord, kindly visualize the situation, 1975 to 2000 is the check period. During that time, my lord, not everything was computerized. So we tried our best, we tried to bring forth every document possible. But, my lord, there were lacking documents. Now, my lord, there are two things. Either they produce those documents or I get an advantage on 114G of the Indian Evidence Act for adverse presumption. Because those documents are entirely within the domain of the sanctioning authority as well as the authority attached to the government, my lord. So that was not made available to me. So I could not have done this. My lord, only thing I beseech your lordship to consider, if my lord restricts, my lord, if the CBI learned senior counsel for the CBI says that I have been trying to delay, my lord, I say, my lord, in this case, my lord, it has taken 23 years. I have faced the prosecution for 23 years, my lord. It is not that I have tried to delay it. They have had the opportunity to examine 73 witnesses as against me, my lord. All I beseech your lordship to consider for a retired gentleman, my lord, that 2 days be given, one for the IO and one for the sanctioning authority. I'll just cross-examine. There's nothing new that I'm introducing to the story. And these directly relate to, my lord, they will be computing my entire services earning vis-a-vis the but there's a property through which the dispute has arose vis-a-vis a property which probably, allegedly, the person had acquired. So, my lord, there has to be a complete adjudication and assessment of the earning concerned, my lord, and benefits which he has otherwise got. Because during, my lord, I had a word with the client also, my lord. During that time, my lord, there were a lot of other payments which were done through vouchers, and all the papers have to be brought out. My lord, not a very huge job for the prosecution, because, my lord, it is all there in the office. But otherwise, given that they trace back to about 30-40 years back, it is extremely difficult for me to have access to those, my lord, because my lord realizes in 78 he got a reward or additional benefit, my lord. At that time he signed on the papers. That time, my lord, it was not credited to the, my lord, bank account, my lord, directly. So, my lord, it was not very difficult at that point of time. So, my lord, he had certain cash benefits as well, which are there with the office.
Asking you that if,
Sorry, my lord.
for the sake of argument, your application is allowed,
My lord.
the summons will be through court. My query, my query is at the time when you were given the opportunity to adduce the defense witness,
My
what
lord.
take steps for calling service records or the reward or earnings he has made during his tenure in the service. That is my query. Not at the
My
level
lord.
of private witness, but
My
through
lord.
steps were taken calling for the service records.
My lord, my lord. May I say this, my lord? My lord, service records otherwise, in part, were already there on record. My lord, at that point of time, I completely appreciate my lord's concern that I should have been more proactive. But I will kindly realize, my lord, visualize the situation. My lord, most of these people also, they had superannuated by then, my lord. Now, my lord, the difficulty is the moment I stepped up, I also tried to introduce other witnesses. But, my lord, it was not within my capacity, my lord, to bring those documents. That was the only reason that after I finished my defense witness, I took out the application saying that please call, my lord, these two witnesses, not all and sundry, only two witnesses who are the best possible persons. One is the IO who has collected entire service book and everything. My lord realizes last year, in terms of the Honorable Supreme Court's judgment, my lord, even in the criminal rules and orders, there has been an amendment where it has been said all documents, my lord, has to be given. A chart of all documents under 91A of the criminal rule, Calcutta High Court criminal rules and orders, my lord. So that was not the law at that point of time, my lord. So we do not also know that what documents were relied upon or not relied upon. So IO has collected everything, my lord. So I need to see it from the IO, call upon the IO to say, can you show those documents? I'll take that cross-examining the sanctioning authority saying that whether this was placed before you while at the time of cross-examination or not. So I will not take more than 1 day's time, my lord. It is just that let those evidences, it will at best add to maybe a few thousand lakhs, I do not know, my lord, to my salary. Only that much, unless I am allowed, my lord, I will be prejudiced if, my lord, they say X is the amount of the additional benefit that I otherwise got and I say I had legitimately got. So, my lord, that gap can be bridged through those things. So I will not delay. 23 years have passed, my lord. I have not delayed. I undertake, my lord, fixes a time frame, my lord. I undertake, I will take 1 day for the IO and 1 day. And I also undertake, my lord, let it, my lord, be peremptorily in the month of September only, my lord. September, October, whatever, my lord says. Within 3 months, let it be concluded, and that will be last opportunity afforded to me, my lord. Give 3 months time, let the trial be concluded within that point of time, without granting any unnecessary adjournment to either of the parties. Let that be, let there be a direction, my lord. That is what I'm asking, my lord, to consider, my lord. And one more thing, may I just place before your lordship, my lord. Now, my lord, the law is not that, my lord, the law is settled, my lord. However, the learned prosecution, the senior counsel for the prosecution had taken up a point, my lord, on the 2009 judge, my lord is aware that this is an interlocutory order 311, my lord. So it is not amenable to revision. My lord, I completely agree to that stand, my lord, saying and admitting to the extent that it is completely true if the application was made only under 397 and 401, my lord. However, if an application is made under 397, 401 or under 482 for that matter, my lord, the Honorable High Court's power under 482, my lord, it is well settled now, my lord. My lord, the judgments are all there with my learned friend, my lord. He can hand over to your lordship, right from Madhulimaya to, my lord, all judgments are there, to, my lord, Mohan Singh's judgment. Then, my lord, even if, my lord, we take for that matter, my lord, the Pepsi Holdings judgment also, which says, even if my learned senior friend says that why 397, 401 was then mentioned. My lord, Pepsi Holdings, the Honorable Supreme Court has held, nomenclature does not matter. There also similar points were discussed. Well, it is settled now. So I will not be taking much of your lordship's time to, my lord, place all judgments. My lord, judgments are being handed over to your lordship. It is settled. So I am not placing the paragraph by paragraph, my lord. High Court's power, Honorable High Court's power are not circumscribed, or my lord, are not curtailed by the bar under 397. More so in a case of 311. Why so, my lord? I say this. My lord, law is also settled that a person cannot be remediless if he is aggrieved by an order. So, my lord, there has to be a remedy. There has to be either an appellate provision, there has to be some provision. When there is no provision of challenge, it is only under 482 that the Honorable Court can intervene. So, my lord, this is the only provision. My learned senior friend, perhaps he is, my lord, obviously discharging his duties, my lord. He is also aware of it, my lord. My lord is well aware, my lord, there is no other provision under which a 311 applications rejection or allowing can be challenged. If today this view is taken that under 482 also it cannot be done, then my lord, it will attain finality on the learned magistrate or learned sessions judges or additional sessions judges order rejecting or allowing. My lord, there are countless number of judgments, my lord, operating in this field. And my lord, the law is now very well settled, even by larger bench judgments of this Honorable Court. And by this Honorable Court also, my lord, there are multiple judgments, my lord, on this point, my lord. Now, my lord, may I just indicate one or two more things to your lordship? My learned colleague will also hand over to your lordship the judgment delivered in case of my lord 311 judgment. In case of my lord, just give me a moment. Just give me a moment. Thanks, it is very difficult. My lord, in Rajaram Prasad Yadav versus State of Bihar and another reported in, my lord, 2013 14 SCC 461, where the law relating to, my lord, 311 CRPC applications have been crystallized.
State of Bihar.
State of Bihar, sir. State of Bihar. Well, I'll also place an unreported judgment of this Honorable Court reported in, well, not reported, sorry, my lord, in CRR number 2600.
Rajaram Prasad Yadav.
My lord. Rajaram Prasad Yadav. Well, that has dealt with all the Honorable Court's judgments almost. So, my lord, that had crystallized the law. Recently also, my lord Justice, the Honorable Chief Justice of the Honorable Supreme Court has also laid down the law in the similar aspect on similar manner, and that no party can be prejudiced only on the ground that it is my lord, it tries to fill up the lacuna. So that is also not the ground now. So that is as recent as probably a month back or so that the Honorable Supreme Court has passed the judgment on this field. But my lord, Rajaram Yadav, my lord, is aware, my lord, discussed the entire law on the subject, my lord. Then, my lord, Manju Devi is also there, which has, my lord, extensively dealt with the aspect, my lord.
Which paragraph is relevant for your case? You are referring to which paragraph?
My lord, Rajaram.
Yes.
My lord, Rajaram, my lord, there are multiple paragraphs. The difficulties, my lord, tell your lordship. In paragraph 17, my lord would find the entire law has been discussed, my lord. But it has laid down the law. So, my lord, after discussing everything, there was something. But 17 deals with both the sides, my lord. What should be the caution and what should be the approach? It talks about the magnanimous approach as well as the caution to be taken by the honorable courts, by the learned trial courts. And paragraph 18 also says, my paragraph 17 then proceeds to, my lord, the Honorable Supreme Court proceeds to paragraph 18. But it has discussed the law extensively. And my lord, subject to what first from my lord, this particular judgment, since the time it was delivered, has been operating in this field, has not been overruled, and has been, my lord, the judgment which we always refer to, whether for the prosecution or for the, my lord, the accused, my lord. Now, my lord, Manju Devi is also there. 2019, 6 SCC, Supreme Court cases, 203, my lord. Paragraph 14 and 15 are relevant in this judgment, my lord, in Manju Devi. My lord, I would also like to place one judgment delivered by this honorable court in CRR number 2600 of 2019, where the judgment of my lord Sethuraman in Sethuraman's case, which my learned senior friend has referred to, my lord, was dealt with, discussed, and the matter was still, my lord, proceeded with by this honorable court, my lord, as it is, my lord, now probably well settled, my lord, and order was passed in this regard, my lord. Here, my lord, the prosecution had approached. Well, this was discussed. And my lord, I don't know if my lord, my learned senior friend is seriously contending the issue of, my lord, this bar under 397 to be a bar for the honorable court, my lord. In that case, I don't know whether, well, that was for vacating or, my lord, that is for the final argument as well. If they challenge maintainability, I will, my lord, I'm just handing over, my lord, my lord, 1997 4 SCC
Let me
551. Sorry, my lord.
raises that point, you will be given opportunity to reply.
My lord. I appreciate.
Any other?
No, my lord. No, my lord. There are other aspects, small aspects, but this is essentially the same thing. Otherwise, I would have to take your lordship to the facts, my lord. I don't think, my lord, if required, my lord, I can address your lordship on the facts, but my lord, this is the crux of it. So, my lord, I undertake, my lord, within 3 months, my lord. My lord fixes a frame because Puja is intervening. Let it be till end of November. Two dates given, 1 day for precautionary measure. Only cross-examination, nothing more. And I shall conclude, my lord. I undertake. My lord, let that be recorded on behalf of my client.
Yes.
May it please your lordship. My lord, though very eloquently addressed, but I differ with my learned friend. on certain aspects of the case. But there is no quarrel over the proposition that the powers under 311 CRP code gives a wide power and it can be exercised by the trial court at any stage of the trial. But there it comes with a tag that it should be exercised only and only when the trial court finds that the cause of justice will be served. There is something serious evidences are to be found elicited. Now, my lord, before I take your lordship to the maintainability point or interlocutory point, I would beseech your lordship to take up the impugned order. My lord, probably it starts at page 8, if I am not wrong.
Yes. Order dated 18th January.
Lordship. My lord, learned advocate appearing on behalf of the accused person submits that the service book of the petitioner, his personal files or orders that recorded the rewards given to him as well as the pay bills/register bills have not been produced before the learned court, and he also submits that the above mentioned documents have not been produced or withheld by the prosecution. And the learned advocate prays for passing necessary order, directing the Assistant Commissioner Central Excise to cause production of the documents, that is personal file, documents showing the reward earned, arrears of pay and pay bills, register, etc. Your lordship will be pleased to note that this Rajaram Prasad was also cited before the court below. In the next paragraph, my lord, we find it that he also submits the court may allow the petitioner the 311 CRPC at any stage before pronouncement of judgment, and in support of his submission, he placed reliance on the following two judgments of the Honorable Supreme Court and one judgment of the Honorable Calcutta High Court. My lord, we may skip the next part and my lord may come to page 3, because the page 2 is the discussion made by the learned trial judge on the judgment cited in Rajaram Prasad. My lord, page 3 is important for us. It is well settled principle of law that the court may allow any petition under section 13 CRPC at any stage of trial, but it is also settled principle of law that the power under section 313 CRP code must be invoked by the court only in order to meet the ends of justice for strong and valid reasons. I perused carefully the petition filed on behalf of the accused petitioner under section 311 CRPC, read with section 65 of the Evidence Act. In the petition filed on behalf of the accused person, it has been stated that the service book of the petitioner, his personal file or orders that recorded the rewards given to him as well as the pay bills, registrar have not been produced before the learned court. In the said petition, it has also been stated that the above mentioned document has not been produced or withheld by the prosecution. And the accused petitioner prays for passing appropriate order to cause production of the above mentioned documents along with PW 71 and PW 73 for further cross-examination. I also perused the case record, exhibited documents and evidence of DW1 accused Kalipada Sarkar very carefully. On perusal of exhibited document, I found that the service book of the accused petitioner have already been produced before the court, which has been marked as Exhibit 151, collective. My lord may please note that Exhibit 151 is the collective document. That means it got several parts. So the submission made by the learned defense counsel stating the service book of the accused petition has not been produced is totally false. I go through the service book of the accused petitioner, but I did not find any reflection of any order in respect of any reward given by the department to the accused person. I also go through the deposition of DW1. My lord, this is very important. I also go through the deposition of DW1 accused Kalipada Sarkar, and it is found that he never stated in his cross-examination, in his deposition, that his department has passed any order in respect of any reward. And it is also found that the accused petitioner nowhere in his deposition stated that he was given any reward by his department at any point of time for any purpose. From the deposition of DW1 accused petitioner Kalipada Sarkar, it is also found that he, DW1, nowhere in his deposition claimed that had received any reward from his department. Accused petitioner did not claim in his deposition that he was rewarded during his service period, and moreover, there is no reflection in his service book that he received any reward at any point of time. In the service book of the accused petitioner, nowhere it is mentioned that the accused petitioner was rewarded for his work at any point of time. If accused person was rewarded for his work at any point of time during his service period, then he must have stated the same fact in his deposition, but he did not state anything regarding receiving any reward from his department or from any other person. Had the department rewarded the accused person for his work at any point of time during his service period, then that thing would have been noted in his service book. On perusal of service book, it is found that the service book exhibit 151 collectively contains all the orders up to 17/5/2001 in respect of accused Kalipada Sarkar relating to his service, including the matter of his promotion, increment, pay fixation after pay commission, etc. But nowhere in the said service book it is mentioned that Kalipada Sarkar was given any reward. In the present petition, it has been stated that no arrears has been taken into consideration. On perusal of the salary statement, pay particulars of the accused person and his service book, is found that arrear pay has been mentioned in the salary statement, pay particulars of accused person and his service book showing arrear pays were paid to the accused persons many times. It is also noted that after completion of examination of defense witness, one petition on 311 CRPC was filed for recalling DW1 on behalf of the accused person, and on basis of the prayer, DW1 was re-examined on 20/12/2022, and even during his re-examination also, DW1 Kalipada Sarkar did not state that he was given any reward by his department or any other authority during his service period. My lord, it falls from the order that this is not the first occasion he had approached the trial court asking for re-examination. He himself was re-examined. Even that time, he did not disclose that I have, though it was subsequently found out that those are all false. His service book was there. At no juncture, my lord will find that the accused petitioner took this plea before the trial court that my entire service book is not before you. Not once, but twice. As your lordship rightly pointed out that if the document was not in proper order, he may not remember the particulars, but by looking at the service book, he could have found that the book is not in proper order, some document. He never said anything.
When did he superannuate from the service?
Well, I don't have the CD with me, that I have to find out.
But he has retired from service.
He has retired from service. Lordship, further down, if my lord is pleased enough to read, as per the pay bills are concerned, salary statements of accused petitioner from the period 19/11/75 to 11/11/1980 has been produced before the court, and the same has been marked as Exhibit 126. Particulars in respect of pay and allowance of accused petitioner for the period of 4/2/1987 to 23/1992 and 1/11/1999 and 34/2000 has been marked as Exhibit 45. Particulars in respect of pay and allowance for the period of 12/11/1980 to March 84 and for the period from September 1993 to 12/1993 and from 16/10/96 to October 1999 has been marked as Exhibit 46. The salary statement of accused Kalipada Sarkar from so-and-so to so-and-so has been marked as Exhibit 76. And the particulars of pay and allowance of accused petitioner Kalipada Sarkar from so-and-so to so-and-so and from so-and-so to so-and-so has been marked as Exhibit 133 collectively. On perusal of Exhibit 45, 46, 76, 126, 130, it is found that those documents contain basic pay, DA, respective IR, pay advance, festival advance, arrears day, ad hoc bonus, uniform allowance, arrear pay, installments of arrear paid on pay commission, etc. It is also found that the service book also contained the orders in respect of promotion of the accused and pay fixation of the accused person. My lord, a PW 73 was examined and cross-examined for 11 days. My lord will find that in page 5, Second paragraph. In the petition, nowhere any reason is mentioned that why PW 71 and 73 is required to call for further cross-examination. PW 71 accorded sanction for prosecution. PW 73 is the IO of this case and he has been cross-examined on 11 days in great detail, that is 4/12/2017 to 2018. My lord, I am not reading out the dates, my lord will find it. So PW 1 was cross-examined for 71 days.
73.
11 days, my lord, I stand corrected. The petitioner before my lord had twice appeared before the trial court, deposed. Nowhere he ever uttered that I was rewarded, I received so and so payment, I received this monetary reward or whatever reward. Reward, my lord, there may be of many types of rewards. There may be a memento, there may be a certificate, there may be a medallion, there may be a cash reward. But if I receive a reward, if I receive a memento, I will remember it. I may not remember the particulars, but I will remember that I was rewarded on so and so date for so and so thing. So if I go before a court deposing where that in particular information is so important, I will blurt out that I was rewarded on so and so date, I received cash reward, I received memento, I received medallion. He said nothing. Even when the service book was exhibited, that point of time he took no objection that the service book is incomplete. Now he suddenly takes up a plea under application under section 311 that my service books need to be produced, which has been withheld by the prosecution. The application under 311, my lord, only says, my lord is pleased enough to take up the application filed by the accused petitioner. Page 42, my lord. 4, 5, and 6 are relevant, my lord. Yet as a government servant, he has received various amounts due to increase in salary, allowances on promotion to higher posts. During check period 1975-2000, there has been 3 pay commissions that has led to revision of pay, allowances of government servants and receipt of lump sum areas on such revisions. In such case of the petitioner, no such areas has been taken into consideration. Service book of the petitioner, his personal file and orders that are recorded the rewards given to him as well as the pay bills registers have not been produced before this learned court. Service book will also provide indication of the appointment date as well as his promotion to higher posts on different dates during the check period. It appears that the above mentioned documents have not been produced or withheld by the prosecution, thus leading to a situation where his income sources are shown lowered and a case of disproportionate asset emerged. He is thus alleged to be in possession of disproportionate asset to the tune of rupees 22 lakhs during the check period for which he is unable to provide satisfactory explanation. This is apparently clear that unless the service book personal file documents showing the rewards earned, arrears of pay bills, registers as brought before this learned court, the petitioner will suffer irreparable loss and injury. That for just decision of this case, the witness namely Chandravan, PW 71, and the investigating officer namely Siddhartha Chakraborty, PW 73, is very much required to be called for further cross-examination of the case for the ends of justice. Otherwise, the accused petitioner will be highly prejudiced. This petition is made bona fide and appropriate and just. Lordship, we have gone through the order. We have seen that every pay raise, every pay arrear, every pay revision, every promotion, everything has been noted and that has been noticed by the trial court while passing the order. As there is no dispute on the proposition that this petition under section 311 can be filed at any stage in the trial court, there is also no dispute on the proposition that it is the sole discretion of the trial judge to find out that whether that 311 application is at all necessary or not. The trial judge cannot be forced to pass an order. Rather, my lord, my learned friend relied on Ram Prasad Jadhav. My lord might be having the copy of the judgment of the Honorable Appeals Court. Lordship may be pleased to come to paragraph 17 at running page 473. আছে তো তোকে দিয়েছো।
Yes.
From a conspectus consideration of the above decisions, while dealing with an application under section 311 CRPC, read with along with section 138 of Evidence Acts, we feel the following principles will have to be borne in mind by the courts. This is a guideline given. Nowhere, my lord, in Ram Prasad Jadhav, we will find that the Honorable Apex Court says, no, you have to allow. You take into consideration 1, 2, 3, 4, 5, 6, 7, 8, 11 points. And then if you find that still that evidence is lacking, that evidence will clear the confusion if there is any, and that evidence is of such nature that it will have a grave impact on the case, allow it. But here, my lord, we find that the service book was there. Every pay revision, every accounting was done. It was noted, it was marked, it was exhibited. The petitioner had cross-examined PW 71 or 73, the IO, for 11 days together. He himself had come before the court twice. He said nothing. One fine morning, he just wakes up from his sleep and he remembers. My lord, in my limited experience as a trial lawyer, when a document is exhibited, and if we as a trial lawyer find that the document that is being exhibited against my client is not in proper order, the first thing that we utter is objected to. Was that documents exhibited under objection? No. If the trial court had passed an order that these documents are being exhibited under objection, my lord, we could have understood that accused was doubting something. After the evidence has been closed, it has been fixed for arguments. It is clear only to delay this. They brought up this application. And my lord, whether it is under 397 or 482, it is a revision. My learned friend has rightly pointed out, it is a settled proposition that nomenclature or section in the preamble of the application doesn't matter. It is the body, my lord knows, it is the body of the application and the prayer. So this is basically an application for revision. My lord, and the revisional jurisdiction is very limited. My lord, we will look into whether there is a jurisdictional error in the order passed by the learned trial court, whether he exceeded his power and whether he used his power arbitrarily, which he could not have done. And all these three check boxes are ticked, my lord. He did not pass an arbitrary order. He passed a very reasoned order. There was no jurisdictional error on his part. He had the jurisdiction to pass the order. And he had, the learned trial judge, my lord, had passed a 5-page order taking out details of everything that was done. But in the application under 311, even during the submissions being addressed to this honorable bench, we did not find the accused saying that, yes, I was examined twice. Yes, I had the opportunity to examine the IO for 11 days. That was not brought out, which smacks of malafide on the part of the accused petitioner before my lord. My lord, there is another judgment I would like to draw your lordship's kind attention. 2019 14 Supreme Court cases 3 to 8. Swapon Kumar Chatterjee versus Central Bureau of Investigation. 311 nature and scope of powers of court under discretionary mandatory parts of 311 analyzed and explained. Wide power of the court to recall witness for re-examination or further when to be exercised principle 6. My lord, we can, my lord, may take up paragraph 10. The first part of the, may I proceed, my lord? The first part of this section, which is permissive, gives purely discretionary authority to criminal court and enables it at any stage of inquiry, trial, or other proceedings under the court to act in one of the three ways, namely, to summon any person as a witness, or to examine any person in attendance though not summoned as a witness, or three, to recall and re-examine any person already examined. The second part, which is mandatory, imposes an obligation on the court to summon and examine or to recall and re-examine any such person if his evidence appears to be essential to the just decision of the case. My lord, now we need to have a glance at 311. My lord knows it very well. My lord will find the same, just one para above, my lord, in the judgment, my lord. The Honorable Apex Court has quoted it. Paragraph 9, my lord. Section 311 of the Code of Criminal Procedure, for short the code, provides for the power of the court to summon material witness and or examine person present. It reads as follows. Any court may, at any stage of inquiry, trial, or other proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined. And the court shall summon and re-examine or recall and re-examine any such person if his evidence appeared to be essential to the just decision of the case. My lord, the first part says, if I am permitted to analyze, my lord, if trial court has the power to do these things, to call any person to give evidence, if the trial court finds that the evidence of that person is very essential, then only it shall summon. First, the trial court has to hold whether that document, whether that evidence is lacking, and if that evidence is brought on record, as my lord was hinting, that if the evidence is brought on record, what impact it will have on the case. If these two are answered in the affirmative before the trial court, then only the mandatory section comes. Once the trial court comes to the conclusion that this evidence is necessary and the re-examination is necessary, then he has to summon. But the discretion remains with him to decide whether it is necessary or not. My lord will not come across any judgment of any High Court or Honorable Supreme Court where the Honorable Courts has said, no, you have to do it. Come what may. Rain, thunder, shower, once 311 is brought out and laid before you, you, the trial magistrate, allow it. The discretion has been retained proper vigore. My lord, further, Honorable Apex Court in the same judgment said, it is well settled that the power conferred under section 311 should be invoked by the court only to meet the ends of justice. The power is to be exercised only for strong and valid reasons, and it should be exercised with great caution and circumspection. The court has very wide powers under this section to even recall witnesses for re-examination or further examination necessary in the interest of justice. But the same has to be exercised after taking into consideration the facts and circumstances of each case. The power under this provision shall not be exercised if the court is of the view that the application has been filed as an abuse of process of law. My lord, the Apex Court rather affirms the negative view that you have to first decide whether it is real or abuse of process, and if you find that it is abuse of process of law, reject it. I once again read in the, my lord, with the lordship's from the power under this provision shall not be exercised if the court is of the view that the application has been filed as an abuse of the process of law. Here in the case at mind, my lord, the service book was produced. Every pay accounting that was done in the service period of the accused petitioner was before the trial court. I had come, he was examined and re-examined, cross-examined for 11 days. Accused entered the box twice. He did not find any wrong at that point of time. When the service book was marked, when the pay certificates were marked, when the accounts were taken into consideration by the trial court, he did not find wrong. He kept silent. When the entire evidence is over, when the case was fixed for arguments, then he might have realized, it is my surmise, my lord, purely surmise, that I am losing ground. My lord, I beseech your lordship to take paragraph 12 also, where the prosecution evidence has been closed long back and the reasons for non-examination of the witness earlier are not satisfactory. The summoning of witness at belated stage would cause grave prejudice to the accused and should not be allowed. Similarly, the court should not encourage the filing of successive applications for recall of a witness under this provision. All these are here. Earlier also he exercised his power, trial court granted. He had the opportunity to recall and re-examine. Prosecution evidence closed. After the belated stage, he came up with it. The Honorable Apex Court said no, it cannot be allowed. My lord, last portion is this, my lord. Last few lines. Hence, I do not find any valid reason to recall PW 71 and PW 73 for further. My lord, in the impugned order, my lord. I'm sorry, my lord.
Yes.
My lord, I have taken the upper portion in the learned advocate submitted that he want to cross-examine PW 71 and 73 on the production of the documents for which he filed this petition. Learned advocate submitted that he want to cross-examine the PW 71 and 73 relating to matter which will be found in the documents for the production of which the present petition has been filed. When the service book and the pay salary statement accused have already been produced before the court and exhibited, then I do not find any valid reason to direct Assistant Commissioner Central Excise and GST Siliguri to cause production of any such document because it is already before the court. But it is like I am already wearing a coat, I am being asked to put on another coat. My learned friend Mr. Paul standing beside me is already wearing an advocate's gown. He is being asked to put another gown on it. That is absolutely unnecessary. The documents were there. And my lord had rightly pointed out that what was the accused doing when these documents were there? My lord, he did nothing. Not one single application. He had other occasions, he had brought out this application under 311, those were allowed. Not one single application that this document be produced along with the witness. And my lord, we have annexed one judgment of the Apex Court with our objection. And my learned friend has already gone through it and he was in his eloquent address referred to it, Sethuram's case. The facts are similar. Personal documents were called for under section 311. The trial court rejected it. And ultimately, the Honorable Apex Court said no. My lord, this is a very particular judgment of the Apex Court which says an rejection order under section 300. My lord, has the objection?
No,
Our reply, my lord.
our reply, your lord.
This is reply.
Our reply, my lord, affidavit in opposition and reply on behalf of Central Bureau of Investigation. Has already got it.
No. The affidavit in opposition, yes.
My lord, the last,
Part.
after the affidavit is
Yes,
complete.
Sethuram.
Sethuram, my lord. Here, Honorable Apex Court has straight away said that section 311, rejection of section 311 is a purely interlocutory nature. My lord, Modhulimaya first said that interlocutory orders, regarding interlocutory orders, that there are certain orders that may not fall within the embargo of 397(2). But my lord knows Modhulimaya did not call out. First time it came in Vidyacharan Shukla, where the Honorable Apex Court said that there are three types of orders: interlocutory, final, and intermediary. The interlocutory is out of revisional purview. final order is appealable under the code or revisable as it is, as the case may be. But there are certain orders that may not be here, there we term it as intermediary. Those are amenable to 397. And the embargo of 397(2) is not operating there. Subsequently, it was followed in a lot of cases. My lord, I was not much on the criminal side in my practices. My learned friend might have much more varied experience and stock of judgments in this regard. Bhaskar Bhimani Dinims is there, Amarnath is there. There's a lot of judgments, but coming down, those were in the 80s, 70s, 80s, 90s. But in 2009, the ultimate Supreme Honorable Apex Court said that no, 311 is the interlocutory order. Now, if the argument is advanced, my lord, that 482 can be placed into service, our own Honorable High Court of Calcutta, full bench has decided that when there is a bar under 397 subsection 2, you cannot resort to 482 and make the render 397 subsection 2 OTOs. My lord, I could not carry the judgment. I will supply, and I will supply my learned advocate on record, my friend over here, a copy of that. It is most probably Dukhi Ram's judgment, a 3-judge bench of the Honorable Court head. Now, my lord, another judgment, another judgment that was relied upon by my learned friend was that of CRR 2600/2019. My lord, I would beseech your lordship to take up that judgment relied upon by the learned friend for the petitioner.
Manju Devi.
No, my lord. CRR's Lakshmi Malik.
Lakshmi Malik.
Now, in this case, the 311 was allowed, my lord. There, the Honorable Court said, this court has considered the said judgment and found that the same is distinguishable. In the facts of the case, since in the same decision, the matter had traveled to the lower revisional court, and it is only thereafter the High Court was approached to section 482 and the bar under section 397(3) of the CRPC. Mr. Bhattacharya, learned counsel representing the 7th accused, relied on a decision of the Honorable Supreme Court in the case of Sethu Raman versus Raja Manikkam, reported in 2009, 5 SCC 153. That was relying to my. Particularly paragraph 5 thereof, whereby and whereunder it was held that in view of subclause 2 of section 397 of CRPC, an interlocutory order in a criminal proceeding cannot be assailed either in appeal or in revision under section 482. My lord, the Honorable Court coordinate bench did not say anything more. This court, having examined the impugned order dated September 2, 2019 and finds the reason for recall of the order have been duly recorded in context of section 311 of CRP code. Well, I could not follow the logic of citing the Sethu Raman in this case, because it is the rejection under 311 which is not revisable. But here the 311 application was allowed. Indeed, as the court below has found the object and purpose of section 311 and allowing application at the end of either recalling a new witness or summoning a witness for re-examining can always be ordered and may be imperative in a given situation, particularly when the accused was charged under section 302 of the Indian Penal Code. Now, there is a grave difference, my lord. A case under section 302 Indian Penal Code and an economic offense, Prevention of Corruption Act. My lord, I need not submit before your lordship. Your lordship very well knows the graver the punishment, the more cautious the court is. So under 302, the quality of evidence that will call for the trial court cannot be equated with the quality of evidence that will be called for in an economic offense or in a case of check bouncing. nowhere in the judgment, my lord, will find the facts and the fact situation that is available in the present case was also available there. Here, the documents sought to be relied upon by the accused, which would at a first brush appear that those were not before the court, were before the court. My lord, assuming not admitting that even if the bar under 397(2) is not there, my lord will examine the case on merits. Then also, my lord, it is settled that the revisional jurisdiction of honorable court is to some extent limited by the statute. And the merit, had the case been that he did not have any opportunity, the documents were missed out, as it was an impression was sought to be given by the accused petitioner, the case would have been different, my lord. But he had the opportunity, all the opportunity under the sun. But he did not avail. My lord, the law does not help who is not vigilant. My lord, my humble prayer would therefore be before your lordship to refuse the prayer of the petitioner and reject the revisional application so that the trial can be concluded very early. It is in the stage of argument.
My lord, may I cause a very short reply? I will not take more than 3 to 4 minutes of your lordship's time. My lord, I'm grateful to my learned senior friend, my lord, I must admit, my lord. May I just indicate 2 things. My learned senior friend had cited a judgment reported in 2019 for SCC 328, my lord. That is the judgment he is relying on. Now, my lord, I just went through this, my lord. My lord, kindly see that, in fact, negates the very argument he tendered on behalf, my lord, that it is not maintainable. This was a case where his agency CBI initially, my lord, would find it from 3, 4, and 12. My lord, they had approached this honorable court only because the bar is not there. They are also, my lord, they had approached, or otherwise, my lord, they went to the honorable Supreme Court. They did not say, my lord, this is not maintainable, whatever, my lord. Here, my lord, was a fact where, my lord, paragraph 3, my lord, would find that the CBI had sought to recall a witness. The recalling was allowed. My lord, it was not allowed. My lord, he was given multiple opportunities. The witness did not turn up. They moved this honorable court, my lord. This matter traveled from this honorable court only. This honorable court, my lord, would find in paragraph 4, it is necessary to notice here that the High Court of Calcutta in CRR number such and such, disposed of such and such, gave a last opportunity to CBI to procure attendance of Mr. H.S. Tanuja. It was observed that in case of failure on the part of CBI to pronounce his attendance, procure his attendance, the attendance of the other witnesses and the attendance of other witnesses, and get them examined, the trial court will proceed further with the trial without granting any further adjournment to CBI, keeping in mind that the case is still pending from the year 1985, my lord. So, my lord, in that case, they had only approached this honorable court, sought for a recalling, which was allowed on similar conditions that today I seek before your lordship. That gives me, my lord, would give me a last opportunity. My lord, this is a regular magnanimity which this honorable court has shown from time to time to afford any person an opportunity when he feels prejudiced or aggrieved. My lord, thereafter, my lord, would find from the judgment the CBI still did not do anything. Thereafter, an expeditious disposal order was passed by this honorable court to finish off the trial within, my lord, 6 months. That was again not acceded to. The matter reached this honorable Supreme Court in the year 2019, my lord, which was much subsequent to the honorable court's judgment that my learned senior friend had otherwise relied on, saying that it is not maintainable. There, the honorable Supreme Court had rejected the prayer in order to protect the accused against prejudice. That, my lord, would find that paragraph 12 of the judgment, my lord. So the parameters of 311, I'll take your lordship again to the judgment of Rajaram, which has clearly demarcated how and when it is to be allowed. Well, this was on a different premise altogether, and there also this application was taken up. Opportunity was given to them. It was initially allowed. Then there was another order. They failed on multiple counts in order to protect the accused after, my lord, since 85. After 35 years, my lord, the Honorable Supreme Court stepped in and said that enough of this to the CBI, that you have had your opportunities. The courts have been magnanimous enough to you. The courts have given you opportunities. You failed. Now I cannot prejudice the accused who is suffering the rigors of criminal trial for 35 years, my lord. My lord, the parameters of grant of 311 are completely different when it comes to an accused person. That, my lord, would kindly, at the cost of repetition, my lord, would kindly take up, my lord, 17.11 of Rajaram's judgment once, my lord. Kindly, my lord. My lord, internal page 474, my lord. My lord has found by a statement. Well, it says the court should be conscious of the position that after all, the trial is basically for the prisoners, and court should afford an opportunity to them in the fairest manner possible. In that parity of reasoning, it would be safe to err in favor of the accused getting an opportunity rather than protecting the prosecution against possible prejudice at the cost of the accused. My lord, and then it proceeds. And my lord, earlier also in paragraph number, my lord, since my lord, my learned senior friend has pointed out that I was trying to correct an error. Why did not I tell this about the reward and everything? My lord, I am a 73-year-old man. My lord, even if I did not tell this, my lord, 17.5, my lord, in the preceding page, my lord sees.
Yes.
My lord, the exercise of the said power cannot be dubbed as filling in a lacuna in a prosecution case unless the facts and circumstances of the case make it apparent that the exercise of power by the court would result in causing serious prejudice to the accused, resulting in miscarriage of justice. My lord, they today cannot claim, even if I am trying to fill up my lacuna, even if that is taken to be true, my lord, then also ultimately, my lord, unless they can show it to your lordship that serious prejudice will be caused to them, in case my lord allows my application, affords me 3 months time to conclude the trial, my lord, in that case, my lord, they cannot say they have been prejudiced in a case where they took 3 years to complete, my lord, their own investigation and 20 more years to conclude the trial, that today for 3 more months, my lord, nothing substantial will change. And ultimately today, if I come before your lordship in the appellate jurisdiction, in case I do not succeed before the learned trial court, and my lord feels my lord can even allow 391 applications, my lord, but otherwise it encumbers the whole process. And my lord, it would ultimately be before this honorable court, that means honorable court either way will probably have to decide the issue. So this honorable court will have to, perhaps, my subject to what first from my lord, have to see that the accused is granted all fair opportunities such that there is no occasion for the accused to feel prejudiced, and the accused does not feel that some part of the evidence which could have been brought was not brought. Here, my lord, from page 4 of the honorable, my lord, learned trial court's impugned judgment, my lord would find even the periods which have been mentioned are not continuous, my lord would find. So non-contest periods were given. What happens, my lord has vast experience, my lord knows, my lord, not everything is given, my lord, and they multiply it. What happens, my lord, is in multiplications, at times there are certain rewards which are not there. So pay commission will not reflect those things, my lord. I understand. I have never recalled the IU and the sanctioning authority. I have recalled myself, and there was a re-examination because they had introduced new facts. So re-investigation, re-examination was there. So, my lord, that is on a different premise altogether. All I beseech your lordship to consider is to restrict my lord, if there's an apprehension on the part of the CBI that I might try to delay, I do not say much time. Given even considering the puja vacations, I say let it be concluded by 30th of November, by when the judgment will be passed. That much only, my lord. Because, my lord, nothing else will be there, my lord. Let an opportunity be granted to a man of, my lord, 73 years old only. Sorry, my lord. Very sorry.
Your submission is like that it is the choice of the accused or the essentiality of the evidence that is required in the record?
My lord, the essentiality of the evidence, but my lord, the accused has to be given a special privilege in terms of section 311, my lord, magnanimity probably has to be extended towards the accused. That is how the law stands now. That is my humble submission, my lord, subject to what falls from your lordship.
Mr. Basu, you come to your application,
My lord,
right?
my lord.
The specificity in your application, which gives certain records are not there, which you intend to. What is special about it?
My lord, it says that unless service book, personal file, documents showing rewards earned, arrears of pay, bills and registers are brought. My lord, they are showing, my lord, I have not objected, as my learned senior friend pointed out, I had not objected to the salary slips. Because why will I object? Because that salary slip will show my salary. My lord, there were additional benefits which usually a government servant gets. So, my lord, if entire records are placed, I will just take one day. If entire records are placed, I will, my lord, my lord, kindly visualize the situation. There was no 91A at that point of time. I did not have the opportunity to all documents. Whatever documents prosecution gave, I had the opportunity to see them and cross-examine. Today, since the law has changed with time, today when, my lord, even the criminal rules and order has been changed to extend this benefit, where a person does not feel prejudiced, all the documents which they are not relying upon, my lord, my lords have framed the rules, my lord, very recently, last year only. The change was for a reason. The amendment was for a reason where this Honorable Supreme Court had directed this amendment to be made out. And in terms of that only, this judge, my lord, the act was changed. That documents which are not even relied upon, my lord, those have also to be indicated. So, my lord, all I beseech your lordship to consider that there are documents which they have not relied upon and not given to me. So, my lord, if they, my lord, in all fairness, the prosecution's job is to hand over to the learned trial judge all evidence as possible. Look, the best evidence be produced. My lord would restrict my dilated acts, my lord.
Please, Mr. Basu.
Sorry, my lord, sorry. I get carried away at times.
I cannot put my question, my queries to you.
I'm very sorry. I'm a junior. My lord, kindly pardon me, my lord. I'm very sorry, my lord.
My lord, he is very
I have
energetic in
heard you with regard to the facts of the case. What you
Right.
say, there will not be either of the parties if 3 months is given to conclude the trial or not. I have heard you. Mr. Majumdar has raised the issue of maintainability. I like to have your deliberation with regard to Setu Raman.
My lord.
Yes.
My lord would kindly take up the other judgment Mr. Majumdar had handed over to your lordship. His judgment on.
Which one?
My lord, the 2019 citation, my lord, he had handed over to your lordship.
19. This
2019 judgment.
Upon Chatterjee.
Shopman Chatterjee's judgment, my lord.
But this judgment does not deal with this aspect of whether the
My lord.
reason is maintainable or not.
My lord, today, if my lord kindly visualize the situation, the law is very clear. Then my lord gives him one more day, I will place the judgments. My lord, today, the law is very clear. If there is no alternative remedy to assail an order, my lord, there cannot be any order under the law of the land which, when passed, attains finality. There cannot be any order passed by any forum or by any court which is not amenable to judicial scrutiny by the higher forum. My lord, that, my lord, humbly submit, my lord, that kind of interpretation of law will also derail not only the accused person's right to file applications before your lordship, but my lord, multiple applications of my learned senior friends' agencies also pending before this honorable court, where they have sought for recalling of witnesses. My lord, it would ultimately be a proposition which will defeat the ultimate cause of justice and restrict the honorable High Court's powers under 482. My lord, that interpretation perhaps will defeat the ultimate purpose of the act, my lord. And with regard to Setu Raman, my lord would kindly take up, my lord, this one judgment of Moi 2013, 2019 also, my lord, this they had taken up, my lord. Every time it has been dealt with, my lord, sees the, then with Setu Raman, what had happened was, my lord, there was also an application before the Sessions Court. It got rejected. It moved to the Honorable High Court under revision only. It was a second revision. From that, it moved to the Honorable Supreme Court. And the Honorable Supreme Court says it did not deal with whether 482 was applicable or not. It says that revision was not applicable. My lord, other interpretation, perhaps, my lord, I can give other judgments, gives me one more day's time. My lord, it has been dealt with, my lord. Otherwise, also, I can give the Mohit's judgment, my lord, of 2013. My lord, all judgments, my lord, comes across for 311 are all under, my lord, when it is passed in an SLP, are all against orders passed by the Honorable High Courts across India, my lord. So today, my lord, that was one-off case where it was against a second revision before an honorable High Court, which travelled to the honorable Supreme Court. It did not deal with, my lord, the jurisdiction of or the powers of the honorable High Court under 482-226 of the Constitution of India, which, my learned senior friend is also aware of. That interpretation that a person will be left remediless only when the learned magistrate passes an order. My lord, irrespective, my lord, as an officer of the court, I say this, my lord, irrespective of whether my application today gets allowed or disallowed on merits by your lordship, my lord, that would lead to, my lord, throughout India, my lord, that interpretation will effectively lead to a position of law that no order passed under 311, even in cases of POXO or, my lord, 302, or, my lord, in case of corruption, my lord, can ever be assailed just because, my lord, because otherwise, my lord, appeal does not lie against such an order. So, High Court's power to be restricted by 397 to perhaps under any circumstance, my lord, a case of adjournment or otherwise is a different thing altogether. Will shut the door on everyone. My lord, there are orders, my lord has seen where the learned trial court at times getting very annoyed by the conduct of the accused, prosecution or otherwise, closes evidence. My lord, 311, my lord, is disallowed when it is done, my lord. Then also, my lord, the honorable courts have been agreed. That interpretation, perhaps irrespective, I say, whether my application gets allowed or not by your lordship, that interpretation, my lord, would lead to a, my lord, an absurdity with deepest respect, if that is acceded to, my lord.
Oh, thank you,
My
Mr.
lord, if my lord should, I'm deeply obliged for my lord giving me so much of time, patient hearing. I'm grateful, my lord. I'm grateful.
Order will you pass? No,
I'll make it reserving.
no, reserving order.
Heard Mr. Apollo Basu, advocate for the petitioner. Mr. Sudipto Kumar Mojumdar, learned DSGI for the opposite party CPI, also concludes his argument. The judgment is reserved and made CAB.
Grateful, my lord. Thank
My
you
lord,
for your
thank you, sir. Thank you, sir. My lord, only thing is there's an interim order. My lord, it is there, my lord, till it is full. Sorry, my lord.
Order is
My lord, it is there, it is there, it is there. I was asking others. Grateful, my lord.
Oh, item number 2 CD is there.
2.
2 man.
Awesome, no?
I will do.
I would like, why not with kindly talk to
And on the last date, you referred to a letter of district magistrate stating that these are, what is the page number? Madam, kindly give it to him.
my lord, may I keep my point, my lord? My lord, this comes reason that 4 of my application. 94, 95. 95 onwards. At the gist of the case. The charge sheet of 306 will include FIR.
94.
94, 95, 95. 94, the charge sheet start and 99 is the second page.
Yes.
It's point number 7. Gist indicated WB form number, notification of WB form number 1600 and 1601. These interpreted themselves as Qadi. Paid, issued fake stamp and fake stamp certificates of marriage, which certainly leads to 256, 250, 255, 256, and
No, last day, the question that was put is, suppose there is a charge sheet filed under 326.
326.
Correct. Can there be a charge framed under the attempt to murder?
No, my.
Why not?
Oh, yes, 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 my.
So we were into that.
Yes, my.
The prosecution, as per your prosecution agency, has not quoted some of the sections which were actually required.
Yes, my.
But court at the time of framing of the charge has the ample jurisdiction to incorporate those sections.
Yes, yes, under application of 216 of CRPC.
So, directing for a trace investigation by other authority without indicating any of the latches on the part of the existing investigating authority is uncalled for.
So, while I'm not coming up to that point, it is my request before your lordship. If I have satisfied your lordship that the charge sheet is itself insufficient, so I am requesting your lordship to kindly make an observation to that regard, so that it might help me under section 216 when you apply before the your court for the trial.
That is
So that
court
I
is to
can-
decide.
I can alter the charge.
I cannot take the form of a trial judge and say that you alter the charge.
No, no,
If the
I
charge
am
is decide-
asking for your lordship
No.
observation, not direction.
No, certainly not. If there is no lacune in the part of latches on the part of the investigating authority, then there is no question of re-investigation by any other authority. What is in your application? What is the latches? Say when except the section has not been quoted. Forget about the section. What is the ground? Where are the grounds? The accused, they have been taken into custody. What is the stage of trial? Charge is framed.
My charge sheet is only submitted, charge nothing.
Copy will be supplied and it will be taken. How long this will go on? You filed a application under 173(8). You filed an application under 173(8).
Yes, my lord.
That was allowed.
That was allowed.
Supplementary charge sheet submitted.
Submitted charge submitted, my lord.
Then
They are still closed off. But my lord, in the supplementary charge sheet on the last one, what page number 135, they have made an observation that even after they have got anticipatory bail, they are keeping on working as a misrepresenting themselves as cast. I have also.
where is the FIR?
up to the level 152, 155. So it's our the supplementary charges. The supplementary charges, basically what we have period of the after yearly food understand the charges. We are still pursuing the car, the business, this identification as RBS, we have a document, photocopy of a document where they are signed in the past. Action number one, Mr. Minor which is the national English stamp and signed as Mukta. Action number one. And minor to that effect, minor, we have made a separate complaint, but police are not taking our complaint. No, those aspects cannot be decided in this application. No, but I am not. I'm indicating this before your law that they are contributing. This is the remarks made by the investigating authority. Under page 135. The page annex to the continuation of page of supplementary charge. And the thing is that minor that in this regard, when we have made a complaint for hill station again that they although we put under visible representation and counterfeiting charges, they are still continuing as Kargi. The separate complaint of the defective complaint are not being accepted by the investigating authorities. If it is not accepted, then there is other forum to agitate that. Police inaction. It should be restricted to this case. All cannot be decided in this application. All aspects cannot be decided in this application. No, but this is very clear that minor the state is not even functioning properly with regard to this investigation, and because they are still continuing and the remarks have been made by the investigating authority itself, minor. Add to which they are stating the charge sheet that they haven't seen anything, but I think the document on the back photostat for the minor of 2022. Supplementary page 9. In the direction that we is not allowed monthly work. I'm just finding that. Nine eight. From zero meter each and supplementary cost. Not allowed to same as earlier task, but the and reading out of supplementary charge. Your grievance is against Abdul Mannan. No? Abdul Mannan is one of the accused, but trying to tell Mustafa Kamal Ghaffar. But they have seized the marriage certificate and all.
Sir, my lord, district register also lodged a complaint.
Where is that?
There is, I'm just holding the page this one. Against them, a complaint has been lodged by the district register. What to do if they don't already order?
When was the case initiated?
Yes, my lord.
When was the case initiated?
2019.
When all the seizures have been made?
Yes, my lord. It has been made in the first initial charge, and in supplementary charge, the remark was made, but as to the effect, of seizure, no seizure was.
Yaqub Ali is the petitioner.
Yes, my lord.
No, no.
Yaqub Ali petitioner.
No, my lord.
Who is the petitioner?
Abdul Habib Sarkar.
He has to be difficult to cooperate with this case.
Yaqub is one of the accused.
Yes, my lord.
Yaqub is one of the accused.
Yaqub Ali, yes. one
Yes,
of them.
yes, ma'am. A bracket of 5 is being operating.
Cases are being initiated against the accused persons.
Yes, my lord.
Difficult.
Well, I would request our observation.
Sabak Sabiti.
Nothing more, my lord.
It's been dealing with trial. You cannot show that there is any lacuna or latches to the evidence.
My lord, eventually, my lord, with the charge sheet, they haven't even compared with the FSL report.
But that these things are an application. The conduct TP, they will supply you. It's a procedure. If you don't get any documents, if you don't get any documents at the time of receiving of property, you can apply that. You have to mention that before the trial court.
In your application, you have stated the facts. But you have not stated that what happened after the investigation was taken up. What was the latches on the part of the investigating authority? Where it is stated?
My lord, section 180 under application of 178 the identification what we have made. Where we have needed for investigation for.
Then your relief has been given by the court, allowing that application.
The court has allowed. That after this, my lord, they have filed a charge sheet with speakers. The charge sheet is very, and then a supplementary charge sheet was filed. Charge sheet is still very important because actually laboratory reports are not needed. With regard to authenticity of the.
Where have you stated in your application? Now, every time you come up with a new ground, it will not help you. If you raise a serious allegation of any latches, that should be incorporated in your application. That is not the.
Even if the IO was changed by this observing of the adding of new section for this is not given. But it is quite predetermined, it is quite visible for the prima facie of this case that while a racket is being operated.
Racket, whatever being operated, that already been investigated. What is the problem with the investigation?
Minor, the problem with the investigation is that minor with addition of the charges.
Again, you come back to square one.
I don't have any allegation.
I am asking you what is the latches in the investigation, not asking you the offenses quoted in the charge sheet. What is the latches? Why are you filing application for sending it to CBI or CID? That is the question. Court is there to consider all these aspects. The trial court will consider. But what is your grievance in this application? What is the latches of the investigating authority? They have seized. Supplementary court has passed order for re-investigation. That is allowed. Supplementary charge sheet submitted. Seizures made. No cogent ground has been stated by you in your application for sending it to any other authority for holding investigation. Can you just indicate any grave latches on the part of the investigating
No,
authority?
no, minor.
Nothing. Let the trial commence. Will you withdraw the application or pass order?
Minor, we pass out.
Then I have to record your submission that there are no grounds. But decide first.
Minor, then kindly give me liberty for all of it.
Sir, try to understand. This is not a trial court. You have come up with a prayer for sending it to CBI or CID. You say that there are no grounds. I am asking you whether you will withdraw it or I'll record your submission that there is no such ground. And then I will.
We got to that.
Sir, after this, this master is very honest. After this, go on again.
Mr. Sotodrio Mukherjee, learned advocate for the petitioner. Acha, आगे cause title नहीं. This is an application for further investigation. In respect of proceeding arising out of Kotwali Police Station case number 806 of 2019, dated 21/11/2019 under section 465, 468, 471, 420, 403, 3 by 34 of the Indian Penal Code. Mr. Sotorudrio Mukherjee, sorry sir. Sotorudrio Mukherjee. Very good. Learned advocate for the petitioner submits that please submits that the investigating authority has not mentioned appropriate provisions of law in the charge sheet. However, during the course of hearing, he submits that on the application of the petitioner under 173(8) of the Code of Criminal Procedure, 173 +8. Reinvestigation was allowed and supplementary charge sheet has been filed. He concedes that there is no such flawed or grave latches of the investigating agency. Mr. Niloy Chakraborty, learned advocate for the state, submits that the investigation has been properly initiated and sufficient materials have been collected against the accused. It is found that after completion of investigation, the investigating agency has submitted charge sheet under section 465, 468, 471, 420, 403 by 34 of the Indian Penal Code against all the FIR named accused persons. Further, Akash, supplementary charge sheet has also been submitted in terms of order passed by the court in an application under 173(8) of the CRPC. During the course of hearing, no such latches or flaw in the investigation could be indicated. Accordingly, the revisional application stands discontinued. Any.
Highly obliged, my lord.
What is your name? What is your name?
My name is Soto Rudrio. Orkut.
Rudrio.
Soto Rudrio.
Soto Rudrio. Very good name.
Even I have a complaint with the court officer. They usually mistake my name as Soto Supriya, Soto Rupriya.
Soto Rudrio. Thank you, Mr. Mukherjee.
I'm highly obliged.
Soto Rudrio. Fourth. Where is Mr. Chaudhary? Where is Mr.
My
Chaudhary?
lord, I am appearing from the opposite party, my lord.
For opposite party?
Please be here, so lot of me moving a matter of number one.
What is it? This is the only matter. There is any other applications? Plan is for extension.
Yes.
And we have filed and vacating application also, my lord.
Who came? There will be other matters. Okay. Miss Isha Acharya, you are for opposite party number 2. Sir, you are for opposite party number
2, my lord. I am at
Oh,
senior, my lord. I am-
short passover. Let Mr. Chaudhary come.
My lord, kindly take it up at 2, my lord. I have other matters in principal bench also. If possible, my lord. If possible, my lord.
Isn't at 2 p.m.? If not 2, then after 2.
My lord, my lord. My lord.
May it please your lordship's lord. 5. I am led by Mr. Shomopriya Chaudhary for the opposite party number 2.
I'm for the state, my lord.
I beg to appear for the petition.
This is a case for quashing.
Yes, Lord, washing. Lord, may I speak to the other side, Lord, my voice is not audible. May I speak on this microphone?
No,
To this one.
Oh, acha, yes.
So, Lord, before I take your lordships to the FIR, may I just, Lord, give your lordships a little background, Lord, which would be necessary, because I reply to Didi, because now it appears to be an admitted position. My lord need not look into the papers, my lord. I tell you, lordships, my lord, in Siliguri, there was a tea estate in the name of Lord Chandmoni Tea Estate. Now, the government of West Bengal, Lord, in late 90s, acquired the tea estate and then, Lord, given the tea estate in lease to the de facto complainant for construction of a satellite township. Now, the name of the satellite township is Uttarayan Township. Lord, my lord may have seen the city center in that it's with the township. The city center comes with the township.
City center 2 is Uttara.
Yes, city center in Siliguri, there's a residential complex. Now, Lord, everyone, Lord, there's a race to go and settle down there. Lord, I don't know why, but it's good. It's quite good. Lord, it's quite the area is very pleasant. So now, Lord, what happened is the Lakshmi Township, the de facto complainant, a company, they constructed the township. Now, Lord, after the construction was to some extent over, Lord, they handed over the management of the maintenance to the society created by the residents. Because my lord knows, my lord, the developer constructs and ultimately it is the residents who have to maintain their own area. So it would appear from the FIR itself that the maintenance was done sometimes in, Lord, if I'm not wrong, 2017 itself. Now, after that, Lord, we have not initiated several proceedings. Several proceedings have been initiated in this honorable court with the allegation that the developer is illegally transferring the common areas of the project. Now, with regard to that, there was a master plan. My lord knows, my lord, that SJDA being the development authority, Siliguri Jalpaiguri Development Authority, since it was a lease, the land is ultimately owned by the government like Salt Lake. So, my lord, the SJDA issued a master plan. Like Salt Lake, Lord, there's a master plan. Now, Lord, in that master plan, there were certain plots, Lord, mentioned for such particular purpose. Lord, I tell you, Lord, similar, I had the occasion to appear in one matter in a PIL before the principal bench where, Lord, a land in Salt Lake was being allotted to Mr. Saurav Ganguly, Lord, the cricketer. Not in CA block illegally. So Lord, there was a PIL moved. I moved, Lord, I assisted my senior in that matter. Lord, we succeeded to some extent. Ultimately, Supreme Court, Lord, upheld the master plan and said that whatever is there in the master plan, that's the final, because the master plan is created under the Town and County Planning Act. So you can't do anything with the master plan. Here, there were allegations that the developer is selling, Lord, a common area which is for community hall to somebody to construct a residential house. So several writ petitions have been filed which are pending. We initiated an arbitration proceeding. Because the transfer of maintenance agreement contained an arbitration clause. The association initiated an arbitration. Before going to the arbitrator, Lord, we filed a section 9 and an injunction was passed saying that the room, the common room, the security room or the office room of the association the interest of our interest to enjoy the office room was protected. Then the matter was referred to the arbitrator, Justice Pranab Kumar Chattopadhyay, Lord, is the arbitrator. His lordship was adjudicating. His lordship under section 17 extended that order. Arbitration was going on. There was some dispute in between. Lord, we moved a section 16 application before the commercial judge Siliguri, because the property is situated in Siliguri, praying for, Lord, setting aside of that mandate. But Lord, the order remains there. Now in between, the time has also lapsed. Now under 29A4, we can come to the commercial code itself if the mandate is set aside, or if my application goes, Lord, for extension of time. In between, the developer, what they did, suppressing all these facts, my lord, not stating all these facts, they lodged an FIR saying that the committee members of the association, who are doctors, lawyers, businessmen, Lord, contractor, everybody, they Lord went to the office, and there was a commotion, there was a fight, saying that they named everybody and lodged an FIR. Now that is under challenge before your lordship, Lord. That FIR, we say that it is not only frivolous, harassing, and Lord, this is an abuse of process of law, absolute abuse of process of law. Now, Lord, Justice Mukherjee, Lord, Justice Ajay Kumar Mukherjee passed an interim order. It is there till the first week of August. They, Lord, filed a vacating application, and that vacating application was directed to be treated as an opposition by Justice Sengupta, Justice Joy Sengupta, and we have filed a reply. So, Lord, I will show you, Lordship, primarily, Lord, I should be very candid. I am not a regular in this, Lord, field, but since I was here yesterday and I was doing the arbitration matter, Lord, they came to know that I am here. They got hold of me and said that perhaps your lordship, yesterday, Lord, if you rejected a prayer for an adjournment on our part, they said that you have to somehow come and place the facts before the court. So I'm here. Now, Lord, from the apparent reading of the FIR, I can show, Lord, considering the principles laid down by Bhajan Lal, Lord, that the FIR doesn't disclose, Lord, any commission of any offense. Number one. Number two, it is absolutely vague. Number three, Lord, your lordship knows, Lord, that if I can show, Lord, from the admitted fact by the parties that there have been a continuous pending civil dispute which are being fought loggerheads with regard to the same issue, perhaps a criminal case which has been initiated with the sole motive of, Lord, cause prejudice to the other party or an arm twisting tactics, perhaps your lordship would not, Lord, allow that proceeding to continue and nip the matter in the bud. My lord may have a look at the FIR first, my lord. There are certain anomalies also which I need to show your lordships. Lord, kindly first take page 21 of your lordship's brief. My lords, kindly got it? But the formal FIR of the revision application.
Yes.
Lord, kindly have a look at the date of the FIR at the top right hand side, 31st March 2023. My lords, kindly got it? Now, Lord, kindly see the occurrence of offense day from 30th March 23, time 9 a.m.
Yes.
So according to the formal FIR, the form, the Lord alleged Lord incident occurred on 30th March 9 a.m. Now kindly see the formal complaint, letter of complaint. And Lord, one more thing before I take you to the next page. Kindly see B, information received at PA's on 31st March 17:25 hours. So according to page 21, the incident happened on 30th March 9 a.m. and Lord, the information was given to the police station on 31st March at 5:25 p.m. Now kindly take the complaint. Let me place it now. Lakshmi Township and Holding Limited, formerly known as Lakshmi Township Limited, is a company within the meaning of the Companies Act 2013, which was allotted 393.25 acres of land by Government of West Bengal under a deed of lease dated 21st November 2003 for the development of a satellite township, now known as Uttarayan, situated at so-and-so. Lakshmi Township and Holding Limited, by virtue of the handover agreement hereinafter referred to HOA, dated 20th June 2017, handed over the maintenance and management of the common areas of the said township to Chandmoni Uttarayan Welfare Society, registered in accordance with the provisions of the West Bengal Societies Registration Act, bearing registration number so-and-so. After the handover, it was very important, after the handover of the maintenance, CUWS, that is the Chandmoni Uttarayan Welfare Society, unauthorizedly started using the office premises of Lakshmi Township with the promise that such use is temporary arrangement. Later, CUWS illegally refused to vacate the office premises on frivolous ground, The office space of Lakshmi Township is on the Dag number so and forms part of the lease land allotted to the state government, by the state government under deed number so. Copy of the deed is annexed. So, my lord, if I pause here for a moment, it says that since 2017 we have been using that office. It is an admitted position.
21st November.
21st November 2017. We have been using this office. Or sorry, 20th June 2017, second paragraph. 20th June 2017. We have been using this office.
Second paragraph.
Second paragraph of page 22. Dated, the HOA dated, and then the third paragraph says after handover of the maintenance, we started using it and saying that it's temporary.
Yes,
and we refuse to vacate. So if we read these two paragraphs, my lord, it could be said that since that handover, we have been using it. Since November 21, 2003, Lakshmi Township is the long-term lease of the said plot of land. It is most humbly and respectfully submitted that the office premises is situated outside the boundary wall of the said township and does not form part of the common area. CUWS has no right, title, interest over or any other right whatsoever to utilize the land on which the office is situated.
So Lakshmi is the developer.
Lakshmi is the developer. Now the government granted lease to Lakshmi for the purpose of developing a satellite township. They developed the township. They sold the plots to us. We constructed our independent houses. There are HIG building, MIG building, independent bungalows, and we formed an association which is maintaining admittedly since 2017. Now, kindly take page 20.
They have only allotted the plot. As far as the construction is complete.
Some bungalows are constructed by us. I am not very sure about the HIG and MIG. Perhaps those are constructed by them and sold to the independent flat owners.
Okay.
There are independent yes, lease and sublease. Lease, because the lessee cannot sell.
Sale, transfer.
I completely agree with Mr. Chakraborty. Now kindly take note page 23, or maybe it's a sublease, we could say. Sublease for the remaining period. On the evening of March 30, 2023, Lakshmi Township, for reason of safety and security, kindly mark this, being one of the hosts of prestigious G20 event, requested them to lock the premises till the completion of the event, but they refused to do full stop. This morning, when the security, this morning Lord has to be read in the context that 30th was the last night, this morning is 31st, but in the FIR, formal FIR, the date of incident is 30th. Can you see? This morning, when the security guard requested them again at around 9 AM, group of unruly mob arrived on the spot and started abusing them with filthy language and threatened them with dire consequences. This was done on the instigation and instruction of some of the executive committee members of Chandmoni Uttarayan Welfare Association. The situation got aggravated totally when the mob suddenly became violent and started pushing the security guards with full force and assaulted them with fist and blow. The mob also misbehaved with female security supervisor, namely so-and-so, a tribal lady, and snatched her gold chain. When the situation went out of control, some of the security guards immediately called their friends posted at the office other side for help and intervention. On their arrival, the unruly mob fled away. The executive committee members of CUWS who led the mob deliberately committed offense to fulfill their malign intention. The danger to the lives of the security guards continues to persist as the mob threatened them openly that they would come to their house and kill them in the event the request to lock the said premises is made again. The unjust, violent, unprovoked conduct of CUWS led the security guard and the management to fear and anxiety. Following up the executive, my lord, in the first paragraph, last line, the sentence says, some of the member, now it says following, and the chart I tell you, Lord says, all the elected members have been named here. Lord, I beseech your Lordship, Lord, to read with me again the last sentence of the first paragraph of page 23. This says this was done with the instigation and instruction of some of the executive body member. But now at the last paragraph of 23, he says, following us, the executive members are all residents of Uttarayan so-and-so, Darjeeling so-and-so. Name, kindly see president, vice president, senior president, joint secretary, executive committee member, everybody. Now, there's a chart of elected member in the office, photograph was taken and everyone was named. All and sundry. Then under the facts and circumstances, we request your good self to be kind enough to take suitable action against the office bearers of the CUWS and take appropriate action in accordance with the law and book all the culprits. This was the letter of complaint. Now, my lord, if my lord, kindly for a second take the pen to my lord. সেটা তুমি বলবে চার্জশিট হয়েছে Lord, I would show your lordship one page of the arbitrator's order, then I will take you, or may I just show one by one? Lord, kindly take page 26. That's the order passed by Lord the learned district judge, Lord, on the section 9 application filed by us. Kindly come to the ordering portion at page 29. বলো কি করে হবে না হলে
What was the dispute before what is the dispute before the arbitrator?
Yes, I'm grateful to your lordship. Let me show your lordship. Lord, kindly straightway come to page 33. My lord has kindly got it.
Yes.
Now the issues are there.
It is possible for my lord without this report. Then it's okay, then otherwise.
You do not have the CD.
No, case of March 2000.
Huh?
The base of the act they said is not like.
Investigation whether would be carried or not with this application. FIR at all not discloses of commission of any eligible of whether there is anything or if I can satisfy your lordship on the face of it is bad. Yes, his diary lord has to be produced. I cannot stand in that way because that's beyond my domain. If my lord wants to have a look at the case diary, my lord will ask them to produce. But lord, they have filed a vacating that it should be heard immediately, and I am protected till first. My lord, I don't know, my lord. My lord directs them to keep. Then lord extend the interim order and lord keep it for any other day. But I was showing something. Lord, let me complete that. Lord, can we come to page 33 once? What was the dispute?
My lord, may I make a humble suggestion? My lord, may I make a humble suggestion, my lord? Am I audible, my lord?
Yes.
My lord, Mr. Chakraborty, subject to what Mr. Chakraborty says, since Mr. Chakraborty has gone there physically, he can complete his submission today because neither myself nor Mr. Chakraborty has anything to say about the case diary. Case diary is for the learned counsel appearing for the state to be produced. If that can be produced on Monday, since it is not there. So Mr. Chakraborty can make his submission today. I can come back on Monday and reply to Mr. Chakraborty's legal submissions. And then my lord can hear the learned public prosecutor appearing for the state for subject to lordship's kind approval, of course.
There will be a total division in this hearing.
My lord, the otherwise, because of the case diary,
Take your submission.
Installment hearings lord are difficult.
my lord, I am ready with the hearing. But since Mr. Chakraborty is suggesting that the case diary is required and
Monday I cannot come. Lord, I can.
I am ready, Mr. Chakraborty, I am ready with the hearing. If you do the hearing, I will complete it today.
How can I say that? সিডি তুমি কবে আনতে পারবে? কবে আনতে পারবে সিডি? Now, how soon you can bring the, how soon Mr. Chakraborty the case diary? If you lordship not fixing it not next week Tuesday, because Tuesday matters before justice. We have to come, Lord, the more the merrier, and I can also not actually.
Weather is better here.
Not that, Lord, I am here for last 3 days. I came on Wednesday.
Monday किया थे तुम?
Monday, Lord, would be very difficult for me. Monday would be very difficult for me. Tuesday, I can come. If my lord accommodates Tuesday, I can come. Oh, extend होगा ही। हाँ, जो ওটা হরিশদার ঘরে সময়টা PM রাখলাম তাহলে হয়ে যেত।
We can do it virtually, Mr. Chakraborty. I am also doing it virtually. My lord,
Yes. Tuesday then. Tuesday কতগুলো?
my lord, Tuesday I have some difficulty, my lord.
বোঝো।
My lord, am I audible? Okay, বল।
Audible.
আমার
What is the problem?
অসুবিধা আছে। My lord, Tuesday I have,
Yes.
my lord, if it can be kept subject to my lord's kind correction, Tuesday I have some personal difficulty. Monday or Wednesday I am
Wednesday I'll do it virtually then. I will.
subject to
cannot-
your-
If he has personal difficulty, I cannot not question that. He's my younger brother.
Monday, Mr. Chakraborty, you can do it virtually. I am also doing it virtually.
Lord, Monday difficulty is there's a continuing matter. Lord, first appeal before Justice Mantha and his lordship said that he will not give, the division bench will not give any time. So I don't know how long the first appeal will continue. If I commit to your lordships and cannot join, that will be very, Lord, wrong on my. If it is Wednesday, I'll join virtual. Lord, if my lord fixes some time at 2 PM.
Very well.
Yeah,
Wednesday, my lord,
extend the interim order, Lord.
Chakraborty, learned advocate for the petitioner, seeks for extension of the interim order. Granted earlier on.
Yes, Lord, the interim order was initially passed on. Lord, 3rd May, the first interim order, it was time to time extended. And
3rd
last extended on 12th of July.
2023. Is there any application? No? Any
Lord.
application for extension?
No, it's there till first week of August. So within time, Lord, I'm playing for that.
Mr. Niloy Chakraborty, learned advocate for opposite party number 1, state, submits that he has not received the case diary. State is directed to produce the case diary on the next date fixed. Mr.
Soumya Chaudhary.
Shobhokriya Chaudhary, learned advocate, appears for opposite party number 2, complainant.
Very famous
Let
lawyer.
the order appear on 3rd May 2023.
My lord is keeping it on 9th at 2 PM.
9th. 9th. 2 PM.
Extend कर दिया तो ये
deeply objecting.
Mr. Chakraborty, 9th, 2 PM.
I'm grateful to Lord Siswara.
Oh, ওটাতে একটা দিয়ে দিন সুবিধা রিপ্লাইটা ফাইল করে দিন affidavit in reply and copy দিয়ে দেন affidavit in reply. Yes, yes.
I didn't have anything.
None appears on behalf of the None appears on behalf of the petitioner. Let the matter appear before the next available service.
I can make.
Your Lordship. Yesterday, Lordship, your Lordship heard the insurance company and the lawyer of the appellant, Lordship.
Yes. The field.
Only interest point, Lordship. 171 has not been complied, Lordship.
Give the decision.
Lordship, I have a
Activity of service, Lordship.
citation.
Yes, Lordship. No problem. Yesterday, filed the paper book, Lordship. Return back, Lordship, yesterday.
Only interest point.
Only interest point, Lordship.
Perfect. I have something to say. Yesterday I have mentioned one point of this citation Calcutta 2008 in Kohinoor Begum versus India Insurance Company. Right? In the point number 10, Lordship, there is there has been mentioned that if there has been any delay caused by the payments, then the insurance company should not be held liable for payment of interest. In the other aspect, we can say that if no delay has been caused by the insurance company, then it should not be held liable for the interest.
How do you interpret that?
There is no whisper in the order judgment. There is no whisper at all.
Do not make such interpretation of what is not written in the judgment.
The grant of interest would be hardship upon the owner or the insurance company who were not.
No. You start with para 10. It begins with in our view. Read the entire paragraph.
In our view, ordinarily, if the claim application succeeds and the tribunal comes to a conclusion that any amount of compensation is payable, it should also grant interest on that amount from the date of making the application before the tribunal, unless tribunal finds that for the tribunal finds that for the delay disposal of the claim application, the claimant himself was responsible, and that the grant of interest would be hardship on the owner of the insurance company who were not responsible for the grant of the delayed relief to the claimants. If the insurance company is not causing any delay, then the interest amount should not be imposed upon them.
That portion goes in your favor. What about the other part, which says that ordinarily the interest will be granted if there is no delay on the part of the claimant?
That is very much true. But
you have to read both the paragraphs. It does not say that if there is no delay on the part of insurance company, then it will be absolved and the claimant will not be entitled to receive interest. Does it say so?
that does not literally say so. Your Lordship, there is a
What is the reason given by the tribunal for not granting?
Nothing has been mentioned, Lordship, in the judgment regarding the delay or the caused by the petitioner to that extent.
Is there any finding of the tribunal?
No, there is nothing like that mentioned that there should not be any interest for this reason and so on.
If they are not at fault, why they will not be entitled to receive it? Is there any reason? Sir? Any reason?
There is no reason.
Then
There is no reason mentioned in the document, as it has not, but it is very evident that there was no delay on the part of the insurance company and for proper for maintaining the principle of equitability.
Even there is no delay on the part of the petitioner as well. 2 or 3 days, that too on the part of the, or the request of the insurance company.
this is all. His appeal. Okay. Affidavit of service filed on behalf of the appellant's claimant is taken on record. This appeal is preferred against the judgment and award dated
28th day of February 2023.
28th February 2023, passed by learned additional district judge from Judge Motor Accident Claims Tribunal from a fast track first court Jalpaiguri in MSC case number 222 of 2019, granting compensation of rupees 7673,054 under section 166 of the motor vehicles. After you come back, I will dictate. Any.
Item number 7, lawsuit, I missed the item number 7. Next circuit lawsuit, it can be taken up next Friday, Tuesday or Thursday.
No,
Next circuit. The copy, it was directed to appear before your lawsuit. Service has not been effected, lawsuit. That's why I'm saying. One service has been completed, one service has yet to be completed.
Complete the service, next circuit you mentioned.
The statutory bail application, that's why I'm saying. Statutory bail application lawsuit. Any day on the next week.
The state will be required, you serve the copy. I can please.
That's why I'm saying, any day on the next, any day on next week.
Not possible. You have surrendered before the court.
No.
Hmm?
That's why I'm saying, lawsuit, on Tuesday or Thursday, Tuesday or Wednesday.
Mr. Shah, first you surrender before the court, then pray for bail. Because after 30 days, it's gone. I don't know what is there in the record. You also know that after appellate court passes order, after 30 days, if it is over, then warrant of arrest will be issued. So your same bail prayer goes. Until it goes into custody, about the option of bail. You find it out and then mention.
Next circuit.
Let it appear in the next circuit. Sure. the impact of the case is that on 21/6/2019 at about 10:15 AM, while the victim was going to his school at Jalpaiguri from which he had on his motorcycle bearing registration number WP64P/4597. At that time, the offending vehicle being Maruti Alto car within bracket without any registration number. That the motorcycle of the victim in a rash accident, as a result of which the victim sustained serious injuries and died on the spot. The claimants being the wife, minor son and minor daughter filed application for compensation of rupees 95,96,880 under section 166 of the Motor Vehicles Act 1980. The claimants, in order to establish their case, examine witnesses, three witnesses, and produce document which have been marked as exhibits 1 to 16 respectively. The insurance company also. Question number 1, question number 1, also again the evidence of one witness. By order dated 5th July 2023, service of notice of appeal upon the owner of the offending vehicle. That is what I want to go over. The owner of the offending vehicle has been dispensed with since he did not contest the claim application. Considering the materials on record and the evidence adduced on behalf of the parties, the learned tribunal granted compensation of the discharge. Granted compensation of rupees 7673,050 in favor of the claimants under section 166 of the Motor Vehicles Act 1980. Being agreed by and dissatisfied with the ensuing judgment and above, the claimants have preferred the present divisional claim application. Present appeal. Mr. Govind Sahan and advocate for appeals claimants submits that the learned tribunal failed to grant interest on the compensation amount in terms of section 171 of Motor Vehicles. In light of the above said submissions, he prays for passing necessary order for grant of interest on compensation amount. Mr. So and so, learned advocate for respond number 1 insurance company. Submitted that the learned tribunal has rightly not granted interest on the compensation amount. Since there was since delay in disposal of the claim application was not due to the fault of the insurance company. To buttress his contention, he relies on the decision of this court in HON'BLE BIVAS, having heard the learned advocates for respective parties, the only issue for consideration is whether the claimants are entitled to interest on the compensation amount. Upon going to the Indian judgment of the learned tribunal, it is found that the learned tribunal did not grant interest on the compensation amount, and the interest was granted at default clause. From the Indian judgment, there is no such reason as to, no such reason given by the learned tribunal for not granting interest on the compensation amount. By the learned tribunal for not granting interest on the compensation amount. In Kohinoor Begum Sutra, this court has observed that ordinarily, if a claim application succeeds and the tribunal comes to the conclusion that any amount of compensation is payable, it should grant interest on that amount from the date of making of the claim application before the tribunal. Unless the tribunal finds that delayed disposal of the claim application was due to the claimants. Since there is no such indication of delay in disposal of the claim application on the fault of the claimants, accordingly, the claimants are entitled to interest on the compensation amount. For such reason, the compensation granted by the learned tribunal of ₹7,673,054 shall carry interest at the rate of 6% per annum from the date of filing of the claim application. Claim application. What is the date of filing?
For the rate of filing. Part of issue, 12/7/19.
12/7/2019. The deposit was made before the learned tribunal.
Out of three petitioners, lordship, one is minor. At the time of filing this petition, I think there were two minors. But now one of them has become major. So only petition number 3 is minor. Three. Farin Hawk. Farin Hawk.
No, 6%. In respond number 1, instance company shall deposit the aforesaid interest amount before the by way of check before the learned registrar, Circuit Bench, High Court, Calcutta, at Jalpaiguri, within a period of 6 weeks from date. Upon deposit of the aforesaid amount, with learned research agent shall release in equal shares. Favor the claimants in equal shares. Minor clause. Appellant number 1 being the mother and natural guardian of appellant number minor appellant number 3 shall receive. Your court record will be dispensed with this. Dispensed. No.
Grateful, your lordship.
Yes, my lord, I am appearing for the opposite party number 2.
For the petition.
But it's an it is there.
Yes, madam, it is there.
This is an application for quashing of the FIR.
Yes.
But the case is that it was initiated under section 465, 468, 470, 406, 420, and 120B of the Indian Penal. Now, my lord, before I place the materials of the case, my lord, certain facts are required to be placed. The petitioners before your lordship, my lord, they are the partners of a real estate firm named as Devja Realtors. Lord, in the year 2016, Lord, these petitioners came in contact with the de facto complainant, Lord, who is the OP number 2 before your lordship. Lord, for the sake of brevity, I will be calling him de facto. Lord, OP number 2, he is the de facto. Lord, he offered the petitioners, Lord, the petitioners partnership firm to sell a piece of land. And Lord, an agreed price was settled between them, that was 16 lakh rupees. Lord, so starting from 3rd of October 2016 till 9th of October 2016, they have paid the entire consideration money. Sorry, 28 within a span of 2 years. Yeah. The entire consideration money was paid in part as per the convenience of both the parties. Lord, page 41 to 48 of my application reviews the payment receipts. Now, my lord, after the final payment was made, though initially it was agreed the amount was 16 lakhs, but the total amount was paid as 16 lakh 70,000. Thereafter, my lord, on 21st of August 2018,
16 lakh 70,000 paid.
yes, my lord, the deed of conveyance was executed by the OP number 2, the de facto, in favor of the partners of the partnership firm, my lord, who are the petitioners before your lordship. My lord, the registration of the deed of conveyance was done as a visit commission registration. My lord, that means outside the office of the registration office in some other place. My lord. And that was the chambers of an advocate who prepared the deed. My lord. My lord, may see the deed was numbered as I-5601 of 2018. Deed was registered. My lord. But after the deed was registered, these petitioners, my lord, they prefer a mutation application before the block land and land reforms officer. And my lord, on 26th of November 2018,
What is the name of that concern? Petitioner's concern.
Devja Realtors, DEVZA, my lord, Devja Realtors.
They purchased this land from opposite party number 2 with the consideration price of 16 lakh
70,000.
Yes.
Now, my lord, on after the registration was done, on 26th of November 2018, these petitioners were called by the block land and land reforms officer for hearing of the mutation application. My lord will find page number 71 of my application is the mutation hearing application, the order sheet of the mutation application. But kindly come to page number 71 of the application.
71.
Yes. My lord, have your lordship got it? My lord?
Yes.
Yes. My lord, the proceedings started on 6th of September 2018. Subsequently, notice was issued, service was completed, and my lord, kindly come to next page, 72. My lord, various dates were given. My lord, finally on 26th of November 2018, the proceedings was done in presence of both the parties. Now, my lord, kindly, my lord, allow me to read the relevant portion. Notice duly served. Service written filed with the case record. The petitioner, both the parties, are present on call. The petitioner, both the parties filed Hajira, which is made part of the proceeding. Her petitioners, the petitioners claim that the land in of Moja so and so, jail number so and so, the applicant applied for the following schedule of land. Thereafter, the schedule of land is given, will be recorded in his favor by virtue of document. Examine the documents produced by the petitioner and the investigation report. It is found that the applicant has issued property with a registered instrument of transfer of the following description. So we got the deed number was given thereafter. Now we will kindly come to the next page, 73, and that is the most important part. It says, no objection is filed against the claim of the applicant in respect of the above mentioned plots.
So who were the parties? Those were notified.
OP and the petition.
OP number 2.
OP number 2. But thereafter, the requisite fee has been deposited. The land is not vested in the state. The petitioner is in possession of the scheduled property. So the prayer of the petitioner is qualified to be allowed, and hence order the following plot of Moja so and so, jail number so and so, be recorded in the name of Devja Realtors. So we have the new mutation.
Show me the schedule of the deed of conveyance.
My lord,
schedule of the deed of conveyance.
yes.
That you show me. Which page?
Yes. Lord, page number 49 starts from page 49 to page 70. Your lordship will find the schedule in. Lord, page 83.
78.
Allow me a moment.
75, 78. Majorly. 11 decibels.
Page 57, my lord.
11 decibels.
Yes.
8 decibels. Correct. Yes, continue.
So, my lord, thereafter the mutation proceeding was done. The record of rights was corrected and was made in favor of Delta Realtors. Not everything went well till that time. Thereafter, Lord, after Lord, around the period of a year or more so, Lord, this one of the partners of the firm went to the office of the registration ADSR office and applied for a certified copy. Lord, when he applied for a certified copy, he was informed certified copy cannot be given to him. What was the reason? Lord? Reason was that it has been kept on hold due to some internal problems. And he was informed, he was instructed to go to the office of the senior officer of the registration department to ascertain what is the problem. Lord, as per the instruction, we went to the senior officer, Lord, probably inspector or general of something was the designation. And Lord, there we are informed that in the deed, the stamp duty that we have paid, that was assessed to be deficit stamp duty, and we need to pay more stamp duty. Lord, initially we paid 1,31,250 rupees as stamp duty. And my lord, we were informed that we need to pay more 1,31,250 as a deficit stamp duty. So, my lord, having no recourse, my lord, we had paid the amount as desired by the government. The second payment was made on in the year, my lord, 2021. 2021, my lord, this second payment of 1,31,250 was paid. And thereafter, my lord, the registration department handed us with the same deed, the number of the deed was changed. My lord will find this changed the number deed. Lordship will find in page number 74 of my application. Kindly, my lord, appreciate page 74 once. Page 74, my lord, once. Yes. Yes. My lord will find in the top right corner, my lord, the number I5602/80 has been struck off, and a new number was given I6209/2021. And my lord, in the bottom part, your lordship will find there are two signatures. One, 21st August 2018, that was the initial at the time of registration, and next 7th September 2021 again. So, my lord, same deed was renumbered because an additional payment was done. Since a deficit stamp duty was there, my lord, the deed was kept on hold. But, my lord, I was given the original deed at the time of initial registration. Lordship it will be better, my lord, if your lordship sees the first deed and the second deed together, my lord.
First, second deed is 74.
Second deed, yes, my lord, starts from 74. And the first deed, page 49. Kindly similar 49 and 74 once and compare, my lord, what is the difference?
Yes.
So, my lord, this deed was again signed on the date of making the additional payment of stamp duty. In the meantime, my lord, so here, my lord, from the facts, my lord, it is clear that there was a deficit stamp duty. The department of the government, my lord, asked me to pay the additional stamp duty. I have paid. I was handed over with the deed again with a renumber. Thereafter, what happened? In the meantime, my lord, till this time, my lord, everything was fine. But in the meantime, this de facto complainant, my lord, he filed a complaint before the DLR. that the deed of conveyance has not been done by him. Mutation done in our favor, we record. Acting on his complaint, I was noticed by the BLRO. We went for a hearing. Both the parties were heard. The application was reviewed. Despite our best efforts, my lord, we did not obtain a copy of that order. But, my lord, against that order, my lord, an appeal was carried before the District Land and Land Reforms Officer by the de facto officer. Under section 54 of the WVL. That copy, my lord, we have obtained and it is on record. Page number 98. Again, my lord, that appeal was registered as a miss appeal. Miss appeal number 9 of 2021. My lord, the operative portion is in page 98. Have your lordships found it, my lord? Yes. Order dated 26th of August 2021. We were heard. My lord, one of the petitioner, my lord, he represented the firm and the other partners, and the OP represented himself. Both the parties were heard, and the order has been passed, outrightly rejecting the appeal. My lord. But allow me to read the relevant portion. Yes. Yes. Lord, the CR, that is case record, is taken today for hearing. Both parties filed Hajira, heard them, sealed, registered deed number 5602 dated 21st/8/2018. First July 2018 of ADSR Bartova. It stamped that the appellant had purchased the land and transferred the sale to the OPs through a chain deed number 4675 dated so and so. Thereafter, the OPs got the land renewed in their favor, that is Devja Realtors, while mutation number so and so.
Which page are you referring?
98.
It's not annexed in the, it's not there in the petition.
Yes, yes.
87 is the last page. There is no 98 in the petition. The petition that has been served is not with it.
Just I'll keep in mind, don't worry. But the appellant stated that he never transferred the land and that was done, everything was done keeping him in complete darkness. But such matter cannot be considered at this stage. Hence, the appeal of the petitioner is therefore rejected. The case is disposed of. So, my lord, the appeal before the District Land and Land Reforms Officer was dismissed outrightly, my lord. Thereafter, what happened, my lord? He has exhausted 2 avenues, BLRO, DLRO under the Land Reforms Act. Next, my lord, he prefers a complaint before the learned Additional Chief Judicial Magistrate, invoking jurisdiction under section 156 clause 3 of the Criminal Procedure Code. And, my lord, that led to the registration of the present FIR in blatant violation of the law laid down, my lord, in Lalita Kumari versus Government of Uttar Pradesh, and subsequently, my lord, Priyanka Srivastava versus State of UP. My lord, the law related to 156.3 has very clearly settled by the Honorable Supreme Court in both the judgments. My lord, before I take your lordships to the judgment, but I would like to draw your lordship's attention to section 154 of the CRPC. Yes, well, 154 CRPC, my lord. Subsection 1 says, every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by a person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in his behalf. And thereafter, certain proviso is there, my lord, with regard to specific section. I am not reading that. So, my lord, it says police has a right to register a FIR if any cognizable offence has been reported. 154 subsection 1. Next, my lord, subsection 3. 154 subsection 3. It says any person aggrieved by the refusal on the part of an officer in charge of the police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by a police officer subordinate to him in the manner provided by this court, and such officers shall have all the powers of an officer in charge of the police station in relation to that office. So, Miller, 154.1 and 154.3 is very clear. Miller, first, a person has to exhaust 154.1. If there is a refusal on part of the concerned police officer acting on 154.1, he has a remedy under 154.3. Both are not concurrent, Miller, but subsequent. 154.3 will come after 154.1. Now, Miller, kindly come to page 98. Oh, sorry, not. But there 156.3 application. The relevant portion is page 108, paragraph 19. তোমার application এটা কিছু ভুল হয়েছে I'm giving my book, don't worry. My lord, paragraph 19 please. Paragraph 19, my lord. He says that the complainant thereafter finding no alternative lodged the complaint with the officer in charge, North Bengal Medical College and Hospital Outpost under Matigara Police Station through speed post, white postal receipt number so and so, dated 31st of August 2021. Kindly note the date, my lord. The officer in charge, Matigara Police Station through speed post, white postal receipt number so and so, dated 31st of August 2021. And the Commissioner of Police, Siliguri Police Commissioner through speed post, white postal receipt number so and so, dated 31st of August 2021. But no cogent steps have been taken by the police authority till date. So, my lord, he has clearly stated on the same day, he has sent a letter to the OC, to the IC, and to the Commissioner of Police. So, my lord, the steps given under 154.1 and 154.3 has not been properly complied.
WhatsApp কিছু বলছে
and cannot be conquered. Now, my lord, I come to the judgment of Priyanka Srivastava. My lord, I am not separately bringing out Lalita Kumari because it has been cited in Priyanka Srivastava.
Say 87 pages.
Well, page number 8. Page number 8. Paragraph 23, my lord. Second paragraph from the top. Here, my lord, Lalita Kumari has been cited. May I read, my lord? Have your lordship found it? But second paragraph from the top. 23. Here. Yes. It says, my lord, at this stage, we may usefully refer to what the Constitution bench has to say in Lalita Kumari versus Government of UP reported in so and so in this regard. The larger bench had posed the following two questions. Number one, whether the immediate non-registration of FIR leads to scope for manipulation by the police, which affects the rights of the victim complainant to have a complaint immediately investigated upon the allegations being made. And the second one, whether in cases where the complaint information does not clearly disclose the commission of a cognizable offence, but the FIR is compulsorily registered, then does it infringe the rights of an accused? So these two questions were raised by the constitutional bench. Thereafter, the next line, answering the questions posed, the larger bench opined thus. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information and that information must disclose a cognizable offense. If any information disclosing a cognizable offense is laid before an officer in charge of the police station, satisfying the requirement of section 154 subsection 1, the said police officer has no other option except to enter the substance thereof in the prescribed form. That is to say, to register a case on the basis of such information. The provision of section 154 of the code is mandatory and the officer concerned is duty bound to register the case on the basis of information disclosing a cognizable offense. Thus, the plain words of section 154(1) of the code have to be given their literal meaning. Next below, it says, it is thus unequivocally clear that registration of FIR is mandatory and also that it is to be recorded in the FIR by giving a unique annual number to each FIR to enable strict tracking of each and every registered FIR by the superior police officers as well as by the competent court to which copies of each FIR are required to be sent. Next, the court gives powers to the police to close a matter both before and after investigation. A police officer can foreclose an FIR before an investigation under section 157 of the code, if it appears to him that there is no sufficient ground to investigate the same. The section itself states that a police officer can start investigation when he has reason to suspect the commission of an offense. Therefore, the requirements of launching an investigation under section 157 of the code are higher than the requirement under section 154 of the code. The police officer can also, in a given case, investigate the matter and then file a final report under section 173 of the code seeking closure of the matter. Therefore, the police is not liable to launch an investigation in every FIR which is mandatorily registered on receiving information relating to commission of a cognizable offense. Kindly note this part, my lord. Next, although we, in unequivocal terms, hold that section 154 of the code postulates the mandatory registration of FIRs on receipt of all cognizable offenses, yet there may be instances where preliminary inquiry may be required owing to the change in genesis and novelty of crimes with the passage of time. On such instance is in the case of allegations relating to medical negligence on the part of doctors. It will be unfair and unequitable to prosecute a medical professional only on the basis of allegations in the complaint. After so stating, the Constitution bench proceeded to state where a preliminary inquiry is necessary, it is not for the purpose of verification or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense. After laying down, so the larger bench proceeded to state as to what type and in what cases preliminary inquiry is to be conducted will depend on the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under. Now, these are the categories. Kindly similar next. Matrimonial disputes, family disputes, commercial offenses, medical negligence cases, corruption cases. Next, Miller, very important. Cases where there is abnormal delay latches in initiating criminal prosecution. For example, over 3 months in delay in reporting the matter without satisfactorily explaining the reasons for delay. The aforesaid are only illustrations and not exhaustive of all conditions which may warrant preliminary inquiry. So, Lalita Kumari is very clear. It says, if there is abnormal delay, for example, 3 months. My lord, in my case, it is 4 years. The delay in lodging the complaint is 4 years, my lord. We have referred to the aforesaid pronouncement for the purpose that on certain circumstance, the police is also required to hold a preliminary inquiry whether any cognizable offence is made out or not. So, Milord, this was the dictum laid down in Lalita Kumari. Next, Milord, kindly come to para 26. Next page, my lord. Now, Milord, this part deals with the application of judicial mile with respect to the judicial magistrate who is entertaining the 156(3) application. 26 says, Milord, have your lordship found it, Milord? Next page, page 10, para 26, second paragraph, Milord, from the top.
Where is the order of the magistrate?
My lord,
Order of the
sir,
magistrate.
that we do not have, my lord. We have only obtained the copy of the FIR. Lord, kindly see 26, what it says. At this stage, it is seemly to state that power under section 156, subsection 3 warrants application of judicial mind. A court of law is involved. It is not the police taking steps at the stage of section 154 of the code. A litigant at his own whim cannot invoke the authority of the magistrate. A principled and really grieved citizen with clean hands must have free access to invoke the said power. It protects the citizens, but when pervert litigation takes this route to harass their fellow citizens, efforts are to be made to scuttle and curb their say. Next, Lord, in our considered opinion, a stage has come in this country where 156(3) CRPC applications are to be supported by an affidavit duly sworn by the applicant who seeks the invocation of the jurisdiction of the magistrate. That apart, in an appropriate case, the learned magistrate would be well advised to verify the truth and can also verify the veracity of the allegation. The affidavit can make the applicant more responsible. We are compelled to say so, as such kind of applications are being filed in a routine manner without taking any responsibility whatsoever, only to harass certain persons. That apart, it becomes more disturbing and alarming when one tries to pick up people who are passing orders under the statutory provision, which can be challenged under the framework of said act or under Article 226 of the Constitution of India. But it cannot be done to take undue advantage in a criminal court as if somebody is determined to settle this case. We have, kindly note this line, Lord, we have already indicated that there has to be prior application under section 154 subsection 1 and 154 subsection 3 while filing a petition under 156 subsection 3. Both the aspects should be clearly spelled out in the application and necessary documents to that effect shall be filed. The warrant for giving a direction that an application under section 156(3) be supported by an affidavit so that the person making the application should be conscious and also endeavor to see that no false affidavit is made. It is because once an affidavit is found to be false, he will be liable for prosecution in accordance with the law. This will deter him to casually invoke the authority of the magistrate under section 156(3). And Lord, next, this is also very important, Lord. Kindly note that apart, we have already stated that the veracity of the same can also be verified by the learned magistrate. Regard being had to the nature of allegations of the case, we are compelled to say so as a number of cases pertaining to fiscal sphere, matrimonial disputes, family disputes, commercial offences, medical negligence cases, corruption cases, and the cases where there is abnormal delay, latches in initiating criminal prosecution, as are illustrated in Lalita Kumari, are being filed. That apart, the learned magistrate would also be aware of the delay in lodging the FIR. So, my lord, this is the ratio of the Honorable Supreme Court in Lalita Kumari and Priyanka Srivastava. My case, my lord, squarely falls within the parameters laid down in the case of my lord Lalita Kumari and also my lord in Priyanka Srivastava.
Date of filing of 156.
It was affirmed on first day of October 2021. And the FIR was lodged on 13th of October 2021. Now, my lord, from the facts, so far, my lord, I have placed till now, my lord, it is clear, my lord, that the de facto complainant, my lord, he has executed the deed of sale. My lord, he has received money. My lord, it is obvious he has received consideration. Thereafter, he has given the registration of the deed of conveyance. He has given his NOC at the time of mutation. And my lord, thereafter, one fine morning, my lord, after 3 long years, one fine morning, he wakes up and he remembers that he needs to file a complaint against these people. Why, my lord? Because he needs nothing without extortion. This is nothing without, this is extortion. That if a complaint is lodged, a criminal prosecution is initiated, there will be a pressure on these people so that some more money can be extorted. These people are they have no business to do with this particular person. They only understand business, and if any dispute of such nature is started, definitely it will be a way to extort some money from these petitions. So this complaint was lodged. Now,
what is the substance of the complaint?
Substance of the complaint, is that he is saying that he never executed the deed of conveyance.
Which one?
The first one. First one is the main one. Second one is the that is the procedural part. I have paid the money, same deed renumbered. He never executed the deed of conveyance. He has alleged in the complaint. He never received any money from me. And one fine morning, he found out from the records that his land has been transferred to the in my favor, in my partnership firm's favor. And thereafter he started making complaints before various authorities, one after another.
It is civil dispute.
Yes, it is a civil dispute, my lord.
Any suit has been filed?
No suit has been filed. It is not even a civil dispute, my lord. But for the sake of argument, let us assume it is a civil dispute. He has never approached the civil court. He has only approached authorities. BLRO, DLRO, nothing happened. Police, then court, and now this criminal prosecution. Now, kindly appreciate a judgment of the Honorable Supreme Court, very recent one, where the interpretation of the sections that has been leveled in this present complaint, and the analogy of the Honorable interpretation was done. The analogy of the Honorable Supreme Court has been given, where civil disputes are given criminal color to pressurize the accused persons. But coincidentally, this judgment arises out from a impugned judgment of our Honorable High Court, and the Honorable Supreme Court has set aside the judgment of this Honorable High Court. Now, the analogy laid down by the Honorable Supreme Court in this case, the Lordship will find from para 21 onwards. Para 21, page number 12. May I start, Mel? Yes. So it says this court has time and again cautioned about converting purely civil disputes into criminal cases. This court in Indian Oil Corporation Supra noticed the prevalent impression that civil law remedies are time consuming and do not adequately protect the interest of the lender's creditors. The court further observed that any efforts to settle civil disputes and claims which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged. Next, at the outset, the respondent number 2 complainant alleged that the appellants were responsible for the offence punishable under section 420, 405, 406, 120B of the Indian Penal Code. Therefore, it is also imperative to examine the ingredients of the said offences, where the allegations made in the complaint, read on their face, attract those offences under the Penal Code. Since the sections are same, I would like to read the interpretation of the Honorable. Section 405 of IPC defines criminal breach of trust, which reads in under. Criminal breach of trust, it says, whoever, being in any manner entrusted with property or with dominion over property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of the property in violation of any direction of law, prescribing the mode in which such trust is to be discharged, or any legal contract express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do, commits criminal breach of trust. The essential ingredients of the offense of criminal breach of trust has been enumerated there under my lord. Number one, the accused must be entrusted with the property or with dominion over it. Second, the persons who are entrusted must use that property. The accused must dishonestly use or dispose of that property or willfully suffer any other person to do so in violation of any direction of law prescribing the mode in which such trust is to be discharged or of any legal contract made touching the discharge of such trust. So, Millard, the essential ingredient of section 405, Millard, is entrustment of property and dishonest inducement of that property. Now, Millard, this person has sold me his property. I have paid consideration money. After 3 years, if he lodges a complaint that he has entrusted me with his property, I have wrongfully induced it.
Criminal activities are going on, but I am learning. Criminal activities are not me. You are hearing criminal matters. So the civilians are released. Today, 3:30 is. 3:30 is there. Mr. Chaudhary will take some time. Good. How are you?
Yes. So, Millard, 405, the ingredients are entrustment of property and wrongful inducement of property. So, Millard, nowhere in the 4 corners of the complaint, he has stated that he has entrusted me with this property, or I have wrongfully induced the property from him. He has sold me the property. And even, Millard, in the complaint, there is no allegation that he has entrusted me with the property. So, Millard, the allegations of 406 goes away. Definition given in the 405 of IPC, make it punishable under 406 goes away. Next, 25, Millard, paragraph 25. It says that definition in the section does not restrict the property to movables or immovables. One, this court in Arcade Almia versus Delhi administration reported in so and so held that the word property is used in the court in a much wider sense than the expression movable property. There is no good reason to restrict the meaning of word property to movable property only when it is used without any qualification in section 405. So, Millard, 405 and 406 is covered by this part. Next, Millard, 27. Paragraph 27, which deals with 415 of the IPC, definition of cheating. 420 is also there in my content note, so I am reading this also. Section 415 says, whoever, by deceiving any person, fraudulently or dishonestly induces persons to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property is said to cheat. So, Millard, this is the definition of cheating, made punishable under section 420. So, what are the essential ingredients, Millard? Given there are the essential ingredients of offense of cheating are deception of any person. Next, Millard, fraudulently or dishonestly inducing that person to deliver any property to any person, or to consent that any person shall retain any property, or intentionally inducing that person to do or omit to do anything which he would not usually do, Millard, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property. So, the fraudulent or dishonest inducement is the essential ingredient of the offense under 415, punishable under 420.
406, 415 follows 405 and 6.
My lord.
So your case is that the entrustment, that there was a sale and the possession to deliver legal.
Yes.
There is no question of any entrustment or any receipt.
Yes. Yes, my lord. Yes. Next, there is a observation in the same judgment. 134. Paragraph 34, page number 16. 34. There can be no doubt that a mere breach of contract is not in itself a criminal offence and gives rise to civil liability of damages. Though here is no breach of contract, but still, however, as held by this court in Hridaya Ranjan Prasad Verma and others versus State of Bihar, and another reported in so and so, the distinction between mere breach of contract and cheating, which is criminal offence, is a fine one. While breach of contract cannot give rise to criminal prosecution for cheating, fraudulent or dishonest intention is the basis of the offence of cheating. In the case at hand, complaint filed by the respondent number 2 does not disclose dishonest or fraudulent intention of the applicants. And same is with me as well, my lord. And finally, my lord, paragraph 42, page number 90. The observation of the Honorable Court with regard to the ingredients of the offence.
With regard to 471 and 467. That is also there.
Yeah, that is also there. But my lord, when the deed has been executed by the complainant in presence of the officials before the ADSR himself, my lord, there is no question of 471. If there is any element of 471, my lord, that must be in the case diagram. It has to be in the case diagram. So, my lord, your lordship can ascertain from the case diagram whether there is any element of 471 or not. My lord, I am coming to that later, my lord. Kindly appreciate 42 once. It says the order of the High Court is seriously flawed due to the fact that in its interim order dated 24th of April 2017, it was observed that the contentions put forth by the appellant vis-a-vis 2 complaints being filed on the same cause of action at different places, but the impugned order overlooks the said aspect, and there was no finding on that issue. At the same time, in order to attract the ingredients of section 406 and 420 of the IPC, to prima facie establish that there was an intention on part of the petitioner and or to cheat and or to defraud the complainant right from the inception. Furthermore, it has to be prima facie established that due to such alleged act of cheating, the complainant had suffered a wrongful loss and the same had resulted in wrongful gain of the accused. Because wrongful loss of the complainant and wrongful gain of the accused, both has to be there. Next, in absence of these elements, no proceeding is permissible in the eyes of law with regard to the commission of the offence, punishable under section 420 of the Indian Penal Code. It is apparent that the complaint was lodged at a very belated stage, as the entire transaction took place from January 2008 to August 2009, yet the complaint has been filed in March 2030. That is after a delay of almost 4 years, with the objective of causing harassment to the petitioner and is bereft of any truth whatsoever. And my lord, on the basis of these observations, the Honorable Supreme Court had quashed the complaint. My lord, so far my case is concerned. From the 4 corners of the criminal, from the 156(3) application, your lordship will not find there is any element of 406, 420 of the IPC. The remaining sections will have 468, 471, that is with regard to forgery. Not if there is forgery, if the deed I have annexed in my application, if it is a forged document, definitely, my lord, the investigation was continued for more than 1.5 years. Thereafter, it was stayed by this honorable court. So there has to be some document to that effect, which time of will establish that my document is forged. And he has not executed any document in my favor. I have made this document purposefully outside the office of the ADSR, and I have used it for transfer of the property. It has some document has to be there by me. Next, my lord. Next, my lord, the celebrated judgment, my lord, which lays down the parameters, my lord, on which High Court under section 482 can quash proceedings. Lord, State of Haryana versus Chaudhary Bhajan Lal, Lord, your lordship is aware, Lord, but still for my satisfaction, I will. Lord, page number 20. Page 20.
Page 21.
Yes. But paragraph 107, that starts from the middle of the page. Have your lordship found it? Yes. Mr. Paracharan, according to whom the allegations in the present case do not make out an offense, drew our attention to a recent judgments of this court in state of UP versus V.R.K. Srivastava reported in so and so, to which one of us, S. Ratnavel Pandian, Justice, was a party. In that case, it has been ruled that if the allegations made in the FIR, taken on the face value and accepted in its entirety, do not constitute an offense, the criminal proceedings instituted on the basis of such FIR should be quashed. The principle laid down in this case does not depart from the proposition of law consistently propounded in a line of decisions of this court. And on the other hand, it reiterates the principle that the court can exercise its inherent jurisdiction of quashing a criminal proceeding only when the allegations made in the FIR do not constitute an offense, and that it depends upon the facts and circumstances of each particular case. In the backdrop of interpretation of various relevant provisions of the code under chapter 40 and of the principles of law enunciated by this code in a series of decisions relating to the exercise of extraordinary power under article 226 or the inherent powers under section 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Now, there are 7 parameters thereafter has been given. I'm reading one by one. Number 1 is where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused person. Next, my lord, second one, where the allegations in the first information report and other materials, if any, accompanying the FIR, do not disclose a cognizable offense, justifying an investigation by the police officer under 156(1) of the code, except under an order of the magistrate within the purview of 155(2) of the code. Next, my lord, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out the case against the accused. My case falls under the third category, my lord. Next, where the allegations in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155(2) of the code. Now, fifth one, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. My lord, I also say, my lord, my case falls under fifth ground also, third and fifth. Next, where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the concerned act provide efficacious redress for the grievance of the aggrieved party. And finally, my lord, the last one, where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with the ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So, my lord, this also applies to me. My lord, ground, third, fifth, and seventh, these 3 grounds laid down in Bhajan's last case, my lord, applies on me. And my lord, if any of the Bhajanlal says, my lord, if any of the ground is satisfied, the Honorable High Court under 482 can quash proceedings for it. After 2 a.m. in the night, last night my server went down. So this is from Indian government. And this I could not obtain from the registered portal from the Indian government. I have downloaded this one. So it is following Milord Bhajan Lal. Bhajan Lal Milord was in 1993. Following Bhajan Lal, this judgment was given. Milord, that is in the year 2013, Rajiv Thapar and others versus Madan Lal Kapoor. Milord, reported in 2013, volume 3, SCC, page 330. Milord, here also certain parameters has been discussed, though Bhajan Lal has been referred here also. My Milord. Milord, page number 30, paragraph 22. Says Milord, the issue being examined in the instant case is the jurisdiction of the High Court under section 482 of the CRPC. If it chooses to quash the initiation of the prosecution against an accused at the stage of issuing process, or at the stage of committal, or even at the stage of framing of charges, these are all stages before the commencement of the actual trial. The same parameters would naturally be available for later stages as well. The power vested in the High Court under section 482 of the CRPC at the stages referred to herein above would have far-reaching consequences, inasmuch as it would negate the prosecution's complainant case without allowing the prosecution complainant to lead evidence. Such a determination must always be rendered with caution, care, and circumspection. To invoke its inherent jurisdiction under 482 of the CRPC, the High Court has to be fully satisfied that the material produced by the accused is such that would lead to the conclusion that their defense is based on sound, reasonable, and indubitable facts. The materials produced is such as would rule out and displace the assertions contained in the charges leveled against the accused, and the materials produced is such as would clearly reject and overrule the veracity of the allegations contained in the accusations leveled by the prosecution complainant. It should be sufficient to rule out, reject, and discard the accusations leveled by the prosecution complainant without the necessity of recording any evidence. For this, the material relied upon by the defense should not have been refuted, or alternatively cannot be justifiably refuted, being material of sterling and impeccable quality. The material relied upon by the accused should be such as would persuade a reasonable person to dismiss and condemn the actual basis of the accusations as false. In such a situation, the judicial conscience of the High Court would persuade it to exercise its power under section 482 of the CRPC to quash such criminal proceedings, for that would prevent abuse of process of the court and secure ends of justice. Milord, based on these observations, next paragraph, Milord, based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of a prayer for quashing raised by an accused by invoking the power vested in High Court under 482 of the CRPC. 4 steps were laid down here. Step 1, whether the material relied upon by the accused is sound, reasonable, indubitable, that is, the material is of sterling and impeccable quality. Step 2, whether the material relied upon by the accused would rule out the assertions contained in the charges leveled against the accused, that is, the material is sufficient to reject and overrule the factual assertions contained in the complaint. That is, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusations as false. Next, Milord, step 3, whether the material relied upon by the accused has not been refuted by the prosecution complainant, and or the material is such that it cannot be justifiably refuted by the prosecution complainant. And finally, Milord, the 4th step, whether proceeding with the trial would result in an abuse of the process of court and would not serve the ends of justice. So if the answer to all these steps is an affirmative, judicial conscience of the High Court should persuade it to quash such criminal proceedings in exercise of power vested in it under section 482 of the CRPC. Such exercise of power, beside doing justice to the accused, would save precious court time, which would otherwise be wasted in holding such a trial, as well as proceedings arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. So, Milord, the law has been laid down by the Honorable Supreme Court very clearly. Steps has been delineated, my Lord. And if the case falls within the parameters of the steps, Milord, this Honorable High Court has ample power jurisdiction, Milord, to quash a criminal complaint in any stage. Now, Milord, my humble submission is, so far as Bhajan Lal's parameters are concerned, and the steps delineated in Rajiv Thapar is concerned, my lord, my case squarely falls within the delineation, my lord, given by the Honorable Supreme Court judgments, my lord. And my lord, finally, I would conclude my submission with a judgment, very recent one, my lord, March 2023, my lord, where the Honorable Supreme Court has stated that criminal jurisdiction is not a money recovery jurisdiction, my lord. If there is even if there is a allegation of dispute relating to payment of money, there are specific civil remedies provided under the law of the land. But since civil remedies are time-consuming process, shortcut process of criminal prosecution are instituted to pressurize the complainants, and ultimately, that amounts to
Is not been stated in the application. The allegations in the 156 clause 3.
Yes.
States of any recovery that any amount is due or not.
He has stated he has not received anything from me. Last one, just what is the observation of the Honorable Supreme Court? Just para 13, only para 13, and I will complete it. Para 13, page number 3, last page. But it says a breach of contract does not give rise to criminal prosecution of cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep a promise will not be enough to initiate criminal proceedings. From the facts available on record, it is evident that the respondent number 2 had improved his case ever since the first complaint, which was filed, in which there was no allegations against the appellant. Rather, it was only against the property dealers, which was in subsequent complaint that the name of the appellant was mentioned. On the first complaint, the only request was for return of the amount paid by the respondent number 2. When the offense was made out on the basis of the first complaint, the second complaint was filed with improved version, making allegations against the appellant as well, which was not there in the earlier complaint. Next, the important part, the entire idea seems to be to convert a civil dispute into criminal and put pressure on the appellant for return of the amount allegedly paid. The criminal courts are not meant to be used for settling scores or pressurize parties to settle civil disputes. Wherever ingredients of criminal offense are made out, criminal courts have to take cognizance. The complaint in question, on the basis of which FIR was registered, was filed nearly 3 years after the last date fixed for registration of the sale deed. Allowing the proceedings to continue would be an abuse of the process of the court, and on the basis of these observations, the complaint was quashed by the Honorable Supreme Court. So, based on the ratio cited by me, but my humble submission before your lordship is that the investigation, the case was initiated in the month of October 2021, and stay was granted by this honorable court in the month of April 2023. So, almost 1.5 years, the case was, the investigation was going on. Though, I was not aware in the beginning. Almost after 1.5 years only, I was called by the investigating officer. That time, I came to know that one criminal case is pending against me. He asked me to appear, though no 41 notice ever was issued to me. He asked me to appear by way of a 91 CRPC notice. I appeared before him. Whatever documents was sought by him, everything was produced before him. I cooperated to the fullest possible extent, with the investigating authorities. Now, my only humble submission is that since 1.5 years investigation continued, the case diary must have some documents which will show the culpability on my part. Why there was a change in the deed? The problem was not with me. The problem was with the department. They have assessed that the stamp duty was deficit. They told me after 1 year, that too when I went to them, they told me that you have to pay more stamp duty. I have paid that. Deed was renumbered in 2021. So, where is my fault? Where is the criminality in the act? There is no criminality. This gentleman, he executed the deed of conveyance. in the presence of officials, in the presence of witnesses, in the presence of Milord the registrar. And Milord, he goes before the DLR at the time of mutation, gives his no objection. And subsequently, Milord, after 3 years, he files this complaint. So, Milord, my culpability, mens rea, is nowhere, Milord. There is no case under the sections level in the complaint. And, Milord, I would request your Lordship, Milord, to ascertain from the case diary, Milord, whether there is any incriminating material against me in the case diary or not. Milord, all the government authorities are involved. BLRO, Milord, the registration department, all are government departments. There must have been some documents. If there is any element of criminality on my part, my Lord. So, Milord, that is my humble submission, Milord. The case, this criminal complaint may be questioned.
My lord, may I start, my lord? My lord, I will start just indicating 2-3 things because I cannot conclude today, my lord, because it's a long submissions made by my learned friend. My lord, I will just indicate one thing today only, my lord.
Not
My
today.
lord, my lord?
Not today.
My lord. For the state, my lord, I would like to have one document, which is very helpful for this.
How long will it take?
My lord, today, my lord, 5 minutes. Today, my lord, 5 minutes I will take.
Next day, how long will it take to conclude?
My lord, I will take 10 to 15 minutes to conclude by Monday, my lord.
My lord, 10 minutes, my lord.
My lord, one thing I just want to show today. My lord, from their document.
8:30, p.m. No, is there any item which has been fixed at 2 p.m.? That is what I. Mr. Chaudhary?
My lord. 2 p.m. My lord.
2 p.m. Sir,
My
8
lord.
p.m. 8 p.m. Okay.
My lord.
Excellent.
My lord.
Heard Mr. Arjun Chaudhary, learned advocate for the petitioner. For paucity of time, the argument could not be on behalf of the other party. Let the matter appear on 8th August 2023 at 2 p.m.
Good.
अच्छा बोले तो जो जहाँ को दिए थे जी चलो
87 onwards. नहीं तो बेशी बोल रहे हैं मैं कॉपी सर्च करना